Sorry, Ms. House, I think I had my sound off on our end. I think you did say something, but I didn't catch it.
I haven't said anything yet. I was just about to.
Sorry, just a second, I still can't hear you. Can you hear me?
Yes.
Okay, great. Now I can hear you too.
All right. Good morning, everyone. Welcome to day 2 of the arguments. This is September 28th. We're in the continuation of the arbitration for the ICF between Woodlands County and the town of Whitecourt. Ms. Roberts, I think we're going to hear the county's argument today, or presentation, whenever you're ready.
Great, thank you. So I am going to begin and do a short overview of where we'll be going, and then I'm going to pass the baton over to my colleague, Ms. O'Kelly, who will speak briefly on one of the subject matters. So what I thought we would do...
Ms. Roberts, we're having issues with your audio.
Can you not hear us?
You're cut in and out if you move your head again.
What am
And now you can talk. Oh,
Ms. Kelly, we can hear you perfectly fine.
Sorry, can you hear us?
That's better.
Okay.
Okay, great.
So what I was saying, sorry, Ms. House, where I was saying we would be going was I will begin with an overview of what our submissions today will look like. And I'll outline some of the themes and some preliminary comments. Then I will be passing the microphone over to my colleague, Ms. O'Kelly, who's going to speak in response to the, in support of our submissions with respect to statutory interpretation and responding to Mr. Swanberg's submissions in that regard from yesterday. So first, I think I just wanted to let you know that we're going to try to cover things under the rubric of 4 themes, sorry. The first will be jurisdiction, and that's the issue with respect to both your jurisdiction and the jurisdiction respecting the contents of an ICF. And secondly, we're going to speak about evidence as a theme, and specifically issues that have arisen with respect to what the evidence says, where there is or isn't any evidence, and some clarification around the language used with respect to references to evidence. And then finally, with respect to the role of evidence in your decision making. Third, we're going to talk about certainty, and that applies both with respect to time, costs, scope, service level, benefits, and third parties, as well as disclosure. Before I ask Ms. O'Kelly to speak to the issue of jurisdiction, I just thought I'd clarify 2 things really quickly. I noted with some confusion myself, Mr. Ward's reference to financial sustainability or fiscal sustainability, and a question about what the county meant by that. I don't know where that reference is being pointed at. One of the issues that the county did put before you as the arbitrator in our joint letter to you was the issue of fiscal stewardship. And I think both Ms. Barney and Ms. Borgo have spoken to that in their respective statements, and it has been addressed as well through other evidence. If I can just walk us backwards in time to where that came from, chronologically, it had a slightly different iteration initially, and that's referenced in Mr. Smill's statement, his general evidence statement of June 30. I wonder if we might just pull that up, and it's the February 5, 2021 letter. And I don't remember the tab number, Ms. Antler. But if we could screen share that, I'll make sure that we're all on the same page. It's about 2/3 of the way down, the appendices.
What was the date you're looking for?
April 22nd, it's a February 5, 2021 letter. It's further down. You're gonna have to scroll down. Yeah. It's the 25. So tab 25 or appendix 25 to Mr. Snow's June 30th statement on general evidence. That was the letter, and we discussed that when Mr. Snow was cross-examined with respect to the proposed letter for voluntary arbitration, setting out some issues that were not identical to those actually put before you, Ms. House, but were the initial iteration. And if we scroll down to item 2 on the first page there, the initial iteration is set out there. Is it fair and reasonable that the terms of the ICF protect the parties from unforeseen expenditures not contemplated within the ICF agreements that they're either required to make or that they will make through this process? Sorry. Sorry, Ms. Antler, I managed to reverse my screen so that it's not on the document. And I'm just readjusting that. There we go. Thanks. So sorry, Ms. Howes, what I was saying was that in essence, that was the first iteration of the issue that ultimately became the fiscal stewardship item. And we see that in the letter that went to yourself from my office, but with the permission of Mr. Ward on behalf of the town. It's dated April 22nd, 2021. I have provided a copy to Ms. Antler and with the request that she put it up. And so that's on the screen now. And if we can go to the top of page 2, that issue is one of the issues that was referred for arbitration and it is set out there. And it says, Woodlands County requires the ability to forecast spending, prepare budgets, and allocate fiscal resources with a degree of certainty that prior intermunicipal agreements with the town of Whitecourt or their interpretation and application did not provide. As such, the county seeks direction from the arbitrator regarding its maximum expenditure. An ICF, sorry, I should say within an ICF, within which that expenditure can be allocated in accordance with Part 17 of the MGA. So that is the issue that is before you for determination with respect to fiscal stewardship. I do not know what the reference to financial sustainability means. And if we need to discuss that, perhaps we can do that in the questioning from you as the arbitrator at the end. And then the second thing I wanted to touch on quickly before we get to the theme of jurisdiction is, what does the county want the ICF to look like? And so this is addressed to some degree within our written submissions. We will not be reciting or reading out our written submissions. We know that you are capable of reading. We know that you have read them, and we trust you to let us know if there are things you have questions about within those written submissions. But otherwise, we will try to complement the written submissions today with our oral submissions rather than replicating them. So first, just a high-level summary of what the county is looking for. We're looking for a fixed-term agreement with an option to extend, although we don't want an indefinite term agreement with a renewal period or a review period. What we have seen in the evidence is that there is already an intermunicipal development plan or IDP in place between these parties that expired in 2018, or sorry, it was due for review in 2018. And because of the breakdown of the relationship between the parties, that has still not occurred. The county is looking for certainty around that issue and specifically a term so that everybody can plan forward with the knowledge that the agreement will come to an end unless it's extended, and they can allocate resources to addressing anything that needs to be revised. Also, with reference to the evidence from Colette Miller, who was relied on by both parties as an expert, wherein she advised, or opined rather, that a 5-year term would also allow not less than 3 years was her recommendation. She suggested 5 in the sense that within 5 years, with an option to renew, things may have changed because there's relatively rapid change these days as opposed to perhaps some time ago in the past. And she gave the example of the electric car charging stations, for example. And with respect to that particular requirement that we're looking for, that there be a fixed term, if there's any questions about that, we're happy to address it. Secondly, we're looking for a lump sum payment, as noted in that fiscal stewardship. We're looking for a maximum expenditure or a fixed amount, so that the county, in its current process of restructuring, which is ongoing and will be ongoing for some years to come, is able to manage that and resource matters appropriately. Third, to the extent that disclosure is required, we would like the disclosure to be transparent and not administratively cumbersome or costly. To the extent that a party chooses to administer the agreement in a manner that is administratively cumbersome, that party in our submission ought to bear the cost for doing so. We've clearly made clear, I think, in our written submissions that the county is opposed to the administrative overhead calculation that has been proposed. And I will.
Ms. Roberts?
Yep.
You're going to have to slow down because you are talking or reading something that you're very familiar with. And I'm trying to capture your argument as well as put it on paper at the same time. So I really appreciate the assistance.
I appreciate you asking, and if I speak back up at some point, please do let me know again. I'm more than happy to slow down. I'm wired this way, and I try to be mindful of it, but often just fail in that regard. So
can you repeat your comments about disclosure so that I can finish my note there before you moved on to the next piece?
Sure. So with respect to disclosure, what the county is looking for is transparency and an agreed method of disclosure that doesn't involve repeat performances, if I can call it that. So there's disclosure, it's simple, it's streamlined, each party knows what to expect and knows what's being disclosed and doesn't need to reinvent the wheel with the information that's provided. I can speak more about that specific point when I'm going to go over the evidence that was given by Ms. Miller. And I would guide you toward that evidence in that regard as well. And I'll get to that later. But just to give a high level sort of sense of where we're going with that, that's one of the things that we're looking for, which we think will benefit both parties. The next thing that I'd mentioned was the county's position is that the administrative overhead that's been proposed by the town is not appropriate. We will speak to that in more detail. Some of that comes up in the statutory interpretation piece that Ms. O'Kelly will address. Some of it also comes up in the other areas around equitable and, excuse me, evidence, as well as certainty. Next, the position that the county is taking is that capital costs, and that is associated also with infrastructure contributions, unless agreed upon by the parties, are not properly part of the ICF. So we are looking to say that is not appropriate. We do see the life cycle plans as essentially capital expenditures. We did hear yesterday, and I would agree with the representation that was made by my friend in response to one of your questions, Ms. Howes, which was that capital assets of the town, when there's a cost share contribution from the county, are operating expenses for the county, but they're capital for the town. And the reverse is also true. So for example, with respect to the airport, if there is a life cycle plan for the airport, a contribution from the town is an operating expense for the town, and it's a capital asset that's being contributed to on the part of the county. And to the extent that what the town is asking for, as we understand it, in their proposal, is a contribution to the replacement of capital assets belonging to the town, and particularly with respect to the two what I'll call big ticket items, and those are fire and recreation. To the extent that there are life cycle plans that are going towards capital assets of the town in that regard, we have some submissions that are specific to that issue to make. But at a principled level, our position is that those life cycle plans really are requests for capital contributions. And To the extent that the parties agree on those, we think they're acceptable. But imposing them goes to the issue of whether or not capital is actually contemplated within the ICF terms in the MGA. And my friend will speak to that. We oppose the contribution for third-party delivered services unless they're agreed upon, or unless the county and the town are both parties to a third-party contractor. So there's privity for both of the municipalities. And we'll explain that a little bit further. It is set out as well in our written submissions. I think that the common theme throughout all of these subject areas that we're going to touch upon is that the county is resistant to and asks that you identify in your decision means of avoiding double standards. So whatever standard applies in the ICF for cost contributions or servicing to one municipality ought to apply for the other. And that is part of the principle of what is equitable as between them. And I think it is also goes to the question of the factor that Mr. Richardson called accountability, such that, and I would understand accountability and I would define it in a manner that is both with respect to the servicing and the cost delivery back and forth, as well as an accountability to the ratepayers, both residential and business. Further, the county has, throughout in its negotiations that were subject to without prejudice privilege, and since then taken the position that it does wish to pay its fair share for services that meet the criteria in the MGA. And that fair share in our submission needs to be objectively determined because the parties haven't been able to agree. And that is what we are looking to you to do. One party cannot dictate to the other what is the fair share. It has to be determined on the evidence because we're here. If we were able to do that ourselves, we would have already accomplished that. On the issue of one other thing that came up, and I think it came up in part, and most notably in Ms. Miller's evidence, was reference to what I would call a force majeure provision in the contract. Nobody has called it that to my knowledge or recollection, and I'm prepared to be corrected, but I don't recall anybody else using that phrase. So I'll just be, and I apologize, it hadn't occurred to me until I went back and re-listened to Ms. Miller's evidence. But what Ms. Miller referred to was unforeseen events. And so the county has requested certainty, and that's part of the fiscal stewardship issue that we've put before you. But I think we also are prepared to address the issue of unforeseen circumstances and look to a force majeure provision. And I can speak to that a little bit more. I apologize for not having given notice of that previously. It has really been an evolution from listening to Mr. Ward and Mr. Swanberg speak yesterday and then going back and rethinking what we were going to argue. So it is a bit organic, and I apologize for it not having a lot of lead time on it. But essentially what we're looking at is to say, is there a means for when something that is unforeseen and out of the control of either of the parties, that there is either it goes to dispute resolution if they can't agree on a resolution, or there are some principled terms in the agreement that provide for the municipalities to work together cooperatively, as opposed to in a fashion that really prioritizes one position over the other. And that really is aimed at looking at the collaboration obligation that is set out in the legislation. So on that note, we had outlined in our Appendix A or Tab A some items that we think belong in the agreement and some that don't. I'm only going to touch on the ones that we say should be in. First is fire. And we have some details about what it is we're looking for. There, we would say we accept that the Whitecourt Fire District, that region, or I think it's called District 1 on the map that was in the old cost share agreement. We're not taking issue with that currently for the current term that we're proposing for this agreement. But the issue that we have identified is that where there is equipment that we think is a capital item, the aerial truck specifically, that the county did not agree to fund and does not agree to being back charged for. The request would be that the Woodlands Fire Chief is involved in making determinations either on a principled, i.e. policy basis, or a one-off basis on when that vehicle is engaged or not, as opposed to being held at the mercy of the Whitecourt Fire Department to decide that and then impose costs correspondingly. Secondly, we would ask that, as it was the case under the previous cost share agreement, the county had pieces of equipment that it purchased and was required to maintain and replace. Those are its capital assets, and it wishes that to continue. The town, as I understand the proposal, is instead for the county to replace, pay into the replacement of the town's equipment. And I think we're saying, to the extent that Whitecourt has four of its own and one shared responsibility fire department, which is the Whitecourt Fire Department and its equipment there, the county would like to maintain its autonomy and be able to acquire and maintain and be responsible for the equipment that it owns at the Whitecourt Fire Hall, as well as at its other locations. And I think this allows the parties the flexibility of determining over the term of their coming ICF, whether or not they want to continue to share these services, or whether, as now for the first time, the county has its own manager of protective services, and it is growing its own fire departments and their training and other the services there. Those service levels may change, and that may ultimately lead to a change in the relationship between the Woodlands County Fire Departments and the Whitecourt Fire Department. And so what we're looking for is to ensure that there's the flexibility to continue to work together, should that be desirable by both councils, or to carry on independently, should that be the preference or the necessity. Water and wastewater, our position is set out in our written submissions. Essentially, it is, we would like the AUC to approve the terms of the water wastewater agreement. We do believe it belongs in the ICF to that extent, but that it still needs AUC approval. We are suggesting that it be of a longer term. And of course, it's subject to review in 5 years. We're looking for the same rates. We resist the 30% revenue sharing, and I will speak to that specifically in the submissions later on. Further, we agree that the landfill item, largely, there is an existing agreement. It is very dated. It's currently based on population on a pro rata basis. The county proposes that instead it be based on volume of waste. That's measurable, and it is measured as it is brought to the facility, and it would more fairly reflect the actual usage. To the extent that there are major costs to be incurred, we would submit that those fees and costs should be put to council for each of the municipalities, and not put through the authority, through the Regional Waste Authority Board, because that board, by definition, will always result in the town having what amounts to a veto, in the sense that because it's proportionately, the service to the town is greater, the representation on the board is greater, it is not possible for each council to meaningfully determine the costs there in any substantial way, because the county's voice is always going to be the lesser voice at the table. With respect to recreation, we have proposed that the facilities that clearly are unique and could create a more significant draw regionally, being the pool and the arenas within the recreation facilities at the town, that the county contribute to those. And we ask that that amount be fixed for the same reason under the fiscal stewardship principle that we had requested previously. And further, that any substantial capital cost contributions from the county to the town for recreation items be approved by both council. And I will address this a little bit more detail, but when I say approved by both council, I mean approved by a quorum of the council of each municipality. I do not mean a recommendation from the Joint Liaison Committee. And with that, that concludes sort of my brief overview of what is in the agreement as requested by the county, and I will ask that Ms. O'Kelly speak to the issue of jurisdiction.
Thank you, Ms. Roberts. Before I begin, I just want to apologize. I've got a bit of a cold. I have been tested, but if I kind of lose my voice or anything at any time or cough, I do apologize in advance. It's just a seasonal thing. So I'm going to address sort of what Mr. Swanberg had addressed in his submission. So this will be our reply to those. And that's the principles of statutory interpretation. But related to that is the question of jurisdiction. Now, we will rely on our written submissions, the ones that were submitted prior to my involvement on the interim application on July 16th, as well as those that were sent to you, Madam Arbitrator, on September 22nd. I will try my best not to repeat those submissions, but simply highlight those that are important to respond to the town's reliance on their previous position of statutory interpretation. Generally, I think it's important for us to start with jurisdiction and the statutory interpretation, because this is the foundation of what we're doing today. Everything that will go into the ICF is provided for under statute. This process is provided for under statute. It's also important because in our submission, the statutory interpretation argument put forward by the town is the fundamental discrepancy or weakness in their argument. And I will get to that when we talk about what is outside your jurisdiction, Ms. House. So the first part is what is inside your jurisdiction. As the arbitrator found in the provisions of the Municipal Government Act, which I'll refer to as the MGA. And thankfully, there are parts of the jurisdiction that the parties appear to agree on. And those parts that you have jurisdiction over as the decision maker include, we agree on what the purposes of the Municipal Governments Act and specifically Part 17.2, they're explicitly provided for therein, and they're canvassed in our written submissions thoroughly. We also agree over whom you have jurisdiction, and those are these two parties here: the town of Whitecourt and the county of Woodlands. We agree that the benefit to the residents of each municipality is a determinative factor in what goes in and out of an ICF agreement. And this is explicitly referred to in the statute. For example, at 708.29 sub 1, where the benefit, it must be described in the contents of the ICF. It also makes an appearance in 708.36 sub 7. And that's when the legislation talks about the possibility of a transfer of revenue, but only where a benefit is derived for those municipal residents who are receiving that service. The fourth principle that we agree on is that any ICF framework must be equitable. Now, that's easier said than done because defining equitable is a great feat. But essentially, I think we all can agree that it is what is fair to the parties in the circumstances. And finally, we agree on your jurisdiction, Madam Arbitrator, over intermunicipal services. What intermunicipal services means is another question. And in that respect, we do disagree over the application of certain provisions, specifically related to benefit, and the evidence that will be required to prove a benefit. Ms. Roberts will get into those in more specific detail. But it's suffice it to say that we do agree that, Madam Arbitrator, you have the jurisdiction to decide these issues. Now, where do we disagree? We disagree on the specific meaning of intermunicipal services. We disagree on the proof.
Excuse me?
Yes?
Again, you're reading, you're going very fast. And so far, I've missed 3 or 4 things you've said. So,
Okay.
Okay, so if I can go back to the 5 principles that I outlined that are within your jurisdiction, and perhaps you can let me know, Ms. Howes, which ones I went too fast on. Would that be helpful? So the first one.
Just a sec. Okay, so you said the benefit of benefit to the residents of a municipality is the determinative factor. And you referenced 2 sections of the act. What were those sections?
The first one I referenced was 708.29 sub 1.
Thank you.
And that specifically says a framework must describe the services to be provided under it that benefit residents in more than one of the municipalities.
So that means to describe the services, not to describe the benefits.
I would read them as together, and if it would be helpful, I can pull up that provision on the screen.
Okay. So I'm asking what your, to clarify what your argument is. So you're saying that I need in the ICF, in the award, I need to describe the services, or I also need to describe the benefits?
I think you don't need to describe the benefit per se, but it does say that the services to be provided under it that benefit residents. That's defining which services fall under it.
Got that. Okay. Then you talk, and the other one was
708.36 sub 7.
okay. Got that one. Okay.
And
Then you talked about equitable, and you said your approach to equitable is what is fair to the parties.
that's right.
Okay. Then you talked about you agree that I have jurisdiction over intermunicipal services. The question is what they are. And then you said 3 things after that. The application of something about evidence.
Okay, I wasn't actually reading, so I'll try my best to summarize it again. So I said we do disagree over the application of these principles, in particular, the benefit.
Okay.
And we do disagree over the evidence that will be required to establish that these conditions are met. And again, that goes to what is required to prove the benefit.
Okay.
And
Okay.
then ultimately, I said those are the issues that we agree the arbitrator has jurisdiction to decide.
Right. Okay. Then you were moving on. Thank you.
No problem. I'll try my best to slow down. Now, I was going to move on to what we disagree on, and that is what falls outside the jurisdiction of the arbitrator in the county submission under the MGA. And I've divided those into 2 general categories. And the first is the jurisdiction of the arbitrator over third parties under the legislation. And the second is the jurisdiction over capital costs and infrastructure. Under that second one, I will address the jurisdiction over life cycles, reserves, and revenue transfers. Now, with regards to the first point, which is the third parties, the position is fairly straightforward, and that is who can be bound by the ICF. We are obviously dealing with statute, and then we're going to deal with a framework, which will be applied through bylaw. But at the end of the day, this is a contract between parties, and it is the county submission that the arbitrator does not have jurisdiction to bind the county to commitments to third parties. And this position is supported by the plain language of the legislation. It talks about 2 municipalities or one or more municipality, or sorry, more than one municipality. But it's also what's equitable. To be very simple, it's just simply not fair to bind the county to a contract or a funding agreement with a third party where there's no privity between those parties. And there's no control over the parameters of that relationship. I think the most obvious example of that, and I won't get into too much detail, is the East Link and mountain bike trail parks that are clearly third parties and should not form any basis of the ICF that comes out of this process. Now, that's it for the position on the third parties to clarify our written submissions and in response to the town. But the second point is that the jurisdiction that is lacking over the award and the ICF framework of capital costs and infrastructure. And there are three principles of statutory interpretation that support the county's position. The first is the presumption against redundancy. The second is the presumption that an amendment is purposeful. And the third is the presumption that an interpretation should not be accepted if it leads to an absurdity. Now, with regards to the first point, which is the presumption against redundancy, and actually all three of them, I did want to address the town's reliance on Section 10 of the Interpretation Act. And as we're all familiar, this is a legislation that is mirrored across Canada, provincially and federally. It essentially codifies the modern principle of statutory interpretation. This is confirmed over and over again in jurisprudence, but the Alberta provision is specifically referred to by the Supreme Court in a case called United Taxis, the citation 2004 SEC 19 at paragraph 8. And that's simply just for the principle that Section 10, and specifically the Alberta's Interpretation Act, reflects this modern principle of statutory interpretation, which neither party agrees applies in this situation.
I missed that last part. Did you say that neither party agrees applies in this situation?
No, I might have done double negative. We both agree that Section 10 and the modern principle of statutory interpretation apply. And the town's agreement is more fully outlined on that principle anyways in their written submissions on the interim application of July 23rd. And I think in relation to that, the important part is that Section 10 is not a deviation from the modern principle and is not a license to engage in a results-driven analysis, which is how we've framed the town's interpretation of part 17.2. Now, with relation to the presumption against redundancy, this is most recently outlined by the Supreme Court in the BC Human Rights Tribunal versus Shrink case, 2017 SEC 6-2. And it's in very simple terms, this just means where the legislature in this case has used specific terms elsewhere in the legislation, that's presumed to have been done for a purpose, and they're not considered to be redundant. There are many terms that the town relies on for their position that are used elsewhere in the MGA, but conspicuously absent from part 17.2. Those include not revenue transfer, capital costs, infrastructure, and reserves. In fact, capital is referred to 86 times in the Municipal Government Act, but not referred to in part 17.2, which governs the scope of an ICF. Now, I will ask Ms. Antler to please pull up page 260 of the Woodlands Book of Authorities. And this is the Shrink case from 2017 that I was referring to. Only because the Supreme Court can obviously explain this much more eloquently than myself. And just at the bottom of paragraph 45 there, it is presumed the legislature avoids superfluous or meaningless words, that it does not pointlessly repeat itself or speak in vain. So in other words, each word that is used has to have some meaning. The most obvious example of this I find in the section 3, the purpose section of municipalities under the Municipal Government Act. And that is where the services and facilities are used as two distinct terms. So it is presumed that facilities means something different than services and vice versa based on this principle. This becomes important when we look at the municipal center, for example, which is the most obvious example. The municipal center is not currently providing any services. It is a plan to build a facility. Given the distinct use of that term facilities, for example, services cannot be read as the town suggests to include things such as facilities. And Ms. Antler, if we could, sorry, I didn't mean for you to take it down. If we could go to the next page whenever you're ready. and specifically paragraph 47. And this is interesting because it speaks about, under this presumption against redundancy, the patterns of expression. And that in this case, again, that relates to the fact that capital is used 86 times in the MGA. So where they say services, that expression cannot be used to include capital investments, costs, infrastructure, whatever the case may be, as they're referred to elsewhere in the MGA explicitly. And in specific response to my friend's position on section 243, that's the section that refers to budgeting requirements. It does refer to reserves there, refers to capital. The point is that these terms under the MGA have a distinct meaning. Related to that case is the Canadian Human Rights Commission case, 2011 SCC 53, that my friend Mr. Swanberg also relied on, and which I think you'll see included various times in our submissions. There were two components to that case. One I'll touch on in a minute, which is the prior iteration of that legislation. But the second one is the use of the term expenses and costs in the Canadian Human Rights Act. Even in the current iteration of the Canadian Human Rights Act, there were other references to costs. However, the Canadian Human Rights Tribunal found that in the lower courts, that the expenses that could be awarded to a successful complainant should include legal costs. And this is specifically outlined at paragraph 45 of that decision. And it's helpful to read from that because it says that it is likely that Parliament would have chosen the familiar legal term of art had it been the intention to confer a power to award costs. The same can be said here, that the legislator would have chosen the familiar term of art, which is capital, if its intention had been to confer the power to grant jurisdiction to the arbitrator over these issues in an ICF framework. And the final point under the, sorry. And the final part under the presumption against redundancy is at paragraph 48. I'm sorry, Ms. Antler, if you could pull it up again for us. And this relates to just the general structure and context of the entire legislation. Oh,
Sorry, where do you want me to be?
oh, sorry, that's the other case, the Shrink case that we were on before. Page 2.
Tab 11.
Page 270, I believe. And it's paragraph, oh, no, this is the wrong one.
Did you read the human rights one?
No, it was the page we were just on in the Schrank case. I don't know why I got there to the right place in the first, 260. Apologies, Ms. Sandler. And it's paragraph 48. And this is where, in this case, the Supreme Court's looking at the overall structure of the code in the Human Rights Code in that case. And it's dealing with this idea that there are specific portions of a legislation to deal with specific, I don't want to call them harms, but specific issues. And so here, while we agree with our friend that there is some overlap between Part 17, which is the planning and development, the IDPs, and Part 17.2, these are more indicative of these two distinct instruments under the MDA to deal with distinct issues. The development and planning of life cycles or whatever it may be falls under Part 17. And Part 17.2 is to deal specifically with the delivery of services, intermunicipal services. So of course there's overlap, they need to be consistent. But we can't read into that you somehow have jurisdiction under 17.2 to do what is contemplated elsewhere in the Municipal Government Act.
I think I'm not following something there. You're saying the IDP is the place where the life cycle plan should be included, which is about equipment and capital?
No, I'm sorry, I misspoke there. The IDP has a different purpose. Similarly, there's the growth management boards. We have all these different purposes, and that there may be overlap in either one of those does not mean that that gives jurisdiction under the ICF part. It's to the contrary. It means that those are intended to be dealt with under various or the other parts of the MGA.
What about section 9 of that? Part 9 of that one section. Mr. Ward referred to it yesterday. So 631 sub 9. You can make note of it and comment on it later if you'd like to.
Ms. O'Kelly, I think you're muted.
Oh, thank you, Mr. Swanberg. Ms. Antler, you can pull this down, and thank you, Ms. Howes. I will address that later just because I don't see that specific provision in the Book of Authorities in paper. So I'll have to pull it up on my computer.
Okay. So I just want to capture one thing before you go on. And that's why I held up my hand. I was trying to make sure I got it right. If the government had wanted to include something like capital, they would have used the familiar term capital. So because that term is not used in Part 17, you're saying I have no jurisdiction over capital.
That's right, but 17.2.
And is that in the sense of services being capital or capital being services, or is it about capital costs and where they fit?
Well, I think I use capital, but when I say capital, I'm referring to capital costs, capital infrastructure. And the reason is that these are terms that are used elsewhere. So if it was intended that the services would include related capital costs, capital infrastructure, the legislation would state that. They would use these terms that are used over and over and over again in the MGA to make that clear. We cannot imply into it the services where it is used elsewhere. And that's the presumption against redundancy that leads us to that analysis. It's not.
Okay, I just want to make sure I have the framework right so I understand. Here you're advancing an argument about the proper interpretation of services. Is that what you're
Yes.
doing?
Yes.
So you're saying because this term is not referenced around the word services, I cannot consider a capital cost or a capital infrastructure to be a service. Is that the gist?
Yes.
Okay. Thank you.
Okay. And what kind of dovetails with that argument is something that the town alluded to yesterday, my friends, is this presumption that an amendment is purposeful. And that is also a well-established provision of statutory interpretation. And it's referred to in the Schrenk case, which we only included an excerpt in our Book of Authorities to avoid inundating you with this, with case law. But it's specifically referred to in paragraph 63 of the Schrenk case, which is hyperlinked in the table of contents in our Book of Authorities. And in that case, the provision it was referring to, it says the evolution of the language of section 13 sub 1b indicates an intention to expand rather than constrain the responsibility for ensuring a discrimination workplace to all who are in a position to discriminate regarding another's employment. But the conclusion is reinforced by the presumption that legislative change is purposeful. And this is the principle that we are relying on in relation to the change that was made through the Red Tape Cost Reduction Act. I might have butchered the name of it, but I'll just call it the Red Tape Act. And a lot was said about the Canadian Human Rights Commission case. That's the 2011 SCC 53 case. And I was actually involved in that case. And what changed in that case was that not only did the Supreme Court say you could look at prior enacted versions of legislation, which is what we have here. But in that case, the Supreme Court expanded the scope of what could be included in legislative evolution to unenacted legislation. And specifically, there was a proposed Canadian Human Rights Act from the 1970s, which was a bill that died on the order paper before it was enacted. When Parliament resumed, this bill made its way before Parliament again with some certain omissions. And one of the omissions that was in that revised bill was that the power to award legal costs was taken out. And the Supreme Court read into that at paragraph 45, and I can have Ms. Antler pull it up for us at page 378. That was the one you were just at, Ms. Antler. Sorry, paragraph 47. And this is the idea that, like I just mentioned, Bill C-72 died on the order paper. And the intention was read into that omission of the cost section. Now, it's important to look at what was omitted in the most recent enactment. And so I've asked Ms. Antler to have ready and available the link that is at footnote 1 of the interim submissions of the county. And this is the prior version of this section. And specifically, we're looking for, sorry, Ms. Antler, 708.29 sub 1. And if there's any way to zoom in. $708.29. Sub F, sub 1F. There we go. And this is what was previously in this section on the contents of the ICF. And in particular, it says may contain provisions for the purposes of developing infrastructure for the common benefit of residents and the municipalities. And this power and this jurisdiction over the related infrastructure for services was removed in the most recent amendment. And as long as Ms. Howe is done looking at that, Ms. Antler, you can take that down. And so, you know, a similar situation happened in the Canadian Human Rights Act where the term cost was taken out. The parties tried to use expenses to include costs. Similarly, here we have service, we have the term infrastructure that's taken out, and the town at least is trying to use the term services to include infrastructure still. And the Supreme Court in the Canadian Human Rights Commission case from 2011 was very clear at paragraph 45. They say the history of the enactment of the provisions in issue supports applying that reasonable inference because the legal term of art cost was used in some draft provisions, but not others. Second, the role and vision for the commission explains why the power to award costs was not part of Parliament's intent. Now, with regards to that second part, we would say that the principle of that this needs to be an ICF needs to be equitable also supports this interpretation. It's not equitable. it's not equitable to require the county to contribute to the capital infrastructure of the town without a corresponding interest in that capital infrastructure or control over that infrastructure and the decisions made in relation to that infrastructure. And this is kind of borne itself out on the facts in this case, which Ms. Roberts will touch on in more detail. But I think the most obvious example is the one with the water and waste treatment. And that's specifically at paragraph 95 of the town submissions, where the county paid a lump sum fee to the town in recognition of past capital costs incurred by the town. Only later to see the town terminate the water service agreement in paragraph 96 on August 29, 2019. Now, my friends make great reliance on Hansard to support their position about the purpose of part 17.2 and the amendments there too. And the specific references to Hansard that the town relies on are in their interim submissions of July 23rd at page 90 and page 115. And page 90, member Sichi talks about the bill does many things in this bill soften or make it easier for municipalities to focus on the issues that are important between them and not on all of the long laundry list of services that they potentially had to go through. And similarly, on page 115, Minister Schweitzer states that this bill is to cut the red tape, of course, but to reduce regulatory burdens and inefficiencies in the process. So neither of these statements is particularly clear on what the purpose of the amendments is, other than to make it more efficient. But in any event, the Hansard, it's pretty well established by the Supreme Court. Hansard must be approached with caution. We don't go digging for Hansard generally unless there's a reason. And we generally don't rely on it unless there's a very clear statement of the purpose of the provision. And that simply doesn't exist here. There's no clear intent, for example, for removing the allowance of infrastructure in ICFs from those general statements. Okay, and the case that supports what I just said is the Canadian National Railway case 2014 SCC 40 at paragraphs 43 to 47. This is the Woodlands Book of Authorities, page 272. And the key references from that case, I'll just read them, are at paragraph 47. The Supreme Court says that while Hansard evidence is admitted as relevant to the background and purpose of legislation, courts remain mindful of the limited reliability and weight of such evidence. Here, Hansard is advanced as evidence of legislative intent. However, such references will not be helpful in interpreting the words of a legislative provision where the references are themselves, and this is the references in the Hansard, are themselves ambiguous. And finally, the final principle of statutory interpretation that supports the county's argument is this principle that an interpretation that leads to an absurdity must be avoided. And for this part, I will just simply reiterate that argument I just made on what is equitable. It is not equitable and not consistent with fiscal stewardship of public resources to require a public body, a government, to invest in another government's capital without a corresponding interest or control over those capital contributions. And in the county's respectful submission, that the absurdity of that and the inequity of it is borne out by that example I just referred to of the payment of $400,000 and then the loss of those services, notwithstanding that capital contribution. So just to sum up on, there are many areas on which we agree on the jurisdiction of the arbitrator. Where we disagree is essentially that definition of services that you pointed out, Ms. House, and what that does and does not include. And specifically, the ICF framework does not include jurisdiction over third parties, does not include jurisdiction over capital costs and infrastructure. The only contemplation of something like that is in the revenue transfer provision. And that is conditioned on there must be a benefit to the municipality and it must be equitable. And so subject to your questions on that particular issue, I will confirm your question, Ms. Howes, in relation to section 631, preferably after a break, just so I can have a quick look at it myself. But subject to your questions, those are our submissions on jurisdiction and statutory interpretation.
Thanks. I just want to bring another, because you use the word infrastructure, in paragraph 10 of your brief, I think you make reference to what an arbitrator may consider when making a decision, and I forget what section of the act it is, but the first one is services and infrastructure. So anything you want to say about the use of the word infrastructure in that part of part 17.2?
Sorry, Ms. House, having not been speaking, I think that it does tie into the 631 sub 9. I wonder if we might just have a few minutes to consolidate the answer to both of those questions.
Yes, I don't have any difficulty with you taking the time. Those are just the questions that I come up with. So
Thank you.
just give me a minute to make sure I got everything else you said. I'll be able to flip through. Ms. O'Kelly, your argument is based around the definition or the meaning of the word services. In your view, are the parties agreed or disagreed on the meaning of costs in part 17.2? You don't have to answer right now.
Yeah, I think we'll take that. It's obviously another, there's the administrative costs issue. So that's a complicated question. I think that will lead us into some accounting arguments as well.
Okay, yeah, I just didn't see anything in your written brief about that, so.
Okay.
I got the sense you were focusing on everything related around services. I'd like to know, will you be making any more submissions around what you consider services to be later on in your presentation? Or was it meant to be covered just here in this part?
Well, I think this is in relation to the statutory definition, but certainly Ms. Roberts will be applying our understanding of that definition to various examples and service areas throughout her submissions.
Okay, so I think the piece, can you clarify for me then? You've given me principles of how to interpret the word services. Can you tell me what your interpretation is, that after applying the principles you did, what is the interpretation that you come up with for services?
Just going to find the reference in our brief. Just give me a moment, please.
You tell me in paragraph 138 that it excludes facilities.
And this is the difficulty without there being a positive statutory definition of what services is, right? So we're left kind of excluding what shouldn't be there by implication based on the statutory interpretation. And services is a very broad term. And so I think it does capture the delivery of services between municipalities. But that doesn't include the infrastructure and the facilities associated with that based on the definition.
Okay, I'm not sure that I still have a clear picture of what you would have me adopt as the definition of services.
Yeah. And I think that we've done our best here at paragraph 132 of our brief, where we rely on dictionary definitions of services. And to take the second one, it talks more or less in relation to, a public good, and it says a system of providing the public with, so what is that service? Whether whether it's fire services or airport services. Wastewater treatment. I don't think anyone disputes that those are all services that are being provided. It's when we get to the benefit question in those ones that we start to, narrow what's within the ICF. Those are services. The county would admit that those are services. And it's not to be forgotten that the word services is always qualified as intermunicipal.
So looking at paragraph 132, and thank you for pointing that out. You're talking about services in the first definition in terms of a public service?
Well, either or, obviously, but the second one, where the fourth meaning says a system of providing the public with gas, water, etc. I think that is probably the most concise we can be in these circumstances. So it's a system, and maybe that's the best stand-in for the word, as opposed to a facility or infrastructure.
Okay, that maybe you'll anticipate, but that leads me to the question of what does a system include?
Well, it's a system that has a deliverable. And obviously, like this is a difficult question. This is why we spent so much time in our brief on this. But the system based on the statutory interpretation, while the plain meaning could arguably include a facility, let's say, could be a service under the plain meaning. But when you apply the principles of statutory interpretation, it doesn't. So we're defining services in a negative way, and system and what it excludes. So what's the expense to the parties to provide that service, not the capital expenses, because that has been, or infrastructure that has been explicitly excluded. That's the reason we exclude it, not necessarily on the plain meaning, it's on the legislative context meaning.
I'm sorry, but I think this is, I'm having some difficulty understanding, and I want to make sure I get your approach clear. Your principles that you advance are very clear. Okay, so but I'm trying to get down to then applying those principles would lead me in the decision now to come up with a definition of service that I then apply against these disputed topics to say, is that a service? Is that a service? Is that not a service? Okay. I think that's where you're having me go. Am I following?
I think we spoke about intermunicipal services respectfully in our written submission. So I don't think that we'd contemplated the question that you're asking presently, although I noticed 10:25. I wonder if the more efficient way for us to utilize your time and ours would be to actually just take a few minutes and maybe provide an answer to that question. And there may still be more questions, but I wonder if it might make more sense for us to sort of put together some thoughts. I have been looking at some of our written submissions and have some thoughts, but rather than speak over Ms. O'Kelly, I wonder if we could just chat with each other briefly, and then Ms. O'Kelly can address the question.
Sure. Okay. Let's take a break then until 10:45, and then we'll continue with your argument.
Okay, thank
And
you.
if you choose to come back with this question tomorrow, I don't have a difficulty with that, so that you can complete your argument. Okay. So.
Okay, thank you.
All right. Okay. Thank you all.
Thank you.
Whenever you're ready, Ms. Roberts.
Yeah, I'll hand over to you. Yep. Okay. Thank you, Ms. Howes, for that indulgence. I think we are going to take you up on answering more thoroughly tomorrow so we don't end up in a rabbit hole about the definition of services, so we can move on to the substantive part of Ms. Roberts' submissions. But I think I may have misspoke when I talked about the systems, because I noticed in section 7 that systems is defined separately as services. So I do want to just have an opportunity to review that and make sure that the definition we do provide you is consistent with the statute as well. But put very, very, very simply, we would say that services are a consumable or a deliverable. They're a commodity, right? And I think where we get to the delivery of that service is in section 708. 0.27, where it says to provide for integrated and strategic planning, delivery, and funding of intermunicipal services. So when we talk about services, it's that end result. It's the Zuma class or the utilities that are the end of that. And the other idea we had is that we could provide you with, I don't think it's the services so much that are in issue. It's whether or not there's services that fall under the ICF. So but one part of that is that it must benefit. Whatever the definition of services is, it should not include what we had made our submission based on earlier today, based on the statutory interpretation. So I will provide you a clearer answer tomorrow, as well as on your question of costs. And I'll turn it over to Ms. Roberts, and she's going to answer your specific question with regards to 631. Sub 9 and the relation to paragraph 10 of our brief, which refers to 708.38.
So on that note, with respect to the question regarding 631 sub 9, so that's within part 17 of division 4. The heading of that section is, or that division, is statutory plans. And then right below that is intermunicipal development plans. 631 is the overarching provision with respect to IDPs or intermunicipal development plans. And subsection 9 follows from subsection 8. And subsection 8 is where there's an enumerated list of what must be included in an IDP. And then subsection 9 says, despite that subsection with all of the list of things that must be in, to the extent that a matter is dealt with in a framework under part 17.2, or what we're calling the ICF provisions, the matter does not need to be included in an IDP. And we would say that, again, reading that together, that we would say to the extent that parties have agreed to address matters in an ICF, they do not need to then replicate that in an IDP. That's the direction from the legislature. And I think it's important to remember that those sections were both put in place with a timeline for compliance that originally was April 1 of 2020. And so I think that what the legislature was intending was to say, if parties are voluntarily agreeing to these things, which we concede, but if parties agree, nothing's stopping municipalities from voluntarily agreeing that they want to include some infrastructure within their ICF. We're saying we don't think that the legislature contemplated you directing that to happen. We think it's distinct. And I think that to the extent that the IDP is clearly the home, the development, the strategic planning and development of not only infrastructure, but also facilities, that is primarily lives in the IDP world. And that's, of course, these things are going to have some degree of intersection in the sense that they're all part of the same part 17 of the MGA. But we would submit that it is not inconsistent for the fact that there's a reference there. It doesn't alter the statutory interpretation that Ms. O'Kelly went through to say that an ICF except for voluntary agreements on things like infrastructure that we would normally deal with through an IDP, you can't impose it on them. It's the similar argument or analogous to the argument that we made in our written submissions with respect to third-party contracts. That if the parties agree, they can agree to be bound in that manner. But we believe that servicing is servicing. Facilities are addressed expressly within part 17.2. And I think that they also is some overlap in section. And to the extent that that is also overlapped with the IDP, it makes sense that there would be a cross-reference. We don't think that you can read in infrastructure when it's been explicitly taken out by the legislature from 17.2.
There you're talking about 708.38? Or are you still just talking about 631?
Oh, in 708.38, yeah, we're saying the services and infrastructure provided for in other frameworks. Sorry, I forgot you were asking that question as well. Other frameworks there, that question goes, I was answering your first question, I apologize. Your second question was about the frameworks. And the frameworks there, I would read 708.38 to be referring to, for example, one of the other frameworks that might be in play there would be an IDP. So to the extent that there are services or infrastructure provided for in the, for example, in this case, in the town and county's IDP that is overdue for review, they don't need to be duplicated, I think was the point I was making a moment ago. And we're saying your jurisdiction does include services and infrastructure provided for other things to which the municipalities are also parties, and that other frameworks would be with reference to the IDP. And I think that's consistent with our friends' submissions around, there's the cross-reference, and I've now forgotten the section, and I put away my notes from yesterday, but the reference, I think it was actually Mr. Ward, not Mr. Swanberg, that spoke about that. But to say that there was a reference back. Sorry, I'm just gonna grab my notes. Sure.
Sub 7.
So it's 708.36 sub 7. I think it was up, I just go back. It was my friend's reference to the revenue transfer. And so there the question was, you can only make an exception for revenue transfer if it's something that's specifically tied back to, what's the next question? And then right above that, that was F that my friend was referring to, and in 708.36 sub 7 sub D, that says an arbitrator must not make an award contrary to an IDP. And so what we're saying is, I think that's consistent with the idea that we would have your jurisdiction includes things that are in the other framework. If we have something that's in an IDP, you can't, we don't disagree. The legislature said you can make a finding that's inconsistent with that. It doesn't mean that I do have some submissions on that specific point to say it doesn't entitle you to incorporate into your decision with respect to the ICF terms that may form part of the IDP that now you're going to impose on the parties in an ICF. I don't think it gives you the liberty to do that. I think it says you can't be inconsistent. It doesn't, and I think that is exactly what my friends are asking for with respect to some of the relief they're seeking, and I'll get to that.
Okay, thank you.
Okay. With respect to this theme, so we've dealt with jurisdiction. The second theme that I had outlined at the beginning was one of evidence. And I think there's a few points here. The first one I'm going to start with is language, and the language that's being used. And so in the submissions, there's some reference in the town's written submissions to the word credible. in relation to evidence. And as I read it, I am inclined to think that the use of the term credibility in some places is being substituted for the word reliability. I can't speak for my friends, but I have a question about that. And so I'm just going to raise it to say, I understand credibility, we understand credibility to be whether or not somebody's believable. Are they telling the truth? Did they inadvertently misrepresent things? Or do they deliberately lie? And reliability is a separate question. Reliability goes to, for example, somebody's ability to recall accurately, whether someone is partial and may be influenced by the position that they hold or the outcome that they're looking for, or whether they're impartial. And so reliable evidence, we have to weigh in those questions as well as the precision of the evidence. And those things all go to weighing out whether evidence is reliable, which is a different question than credibility. If there is before you some suggestion that there's a witness on the county's part that is not credible, i.e. is not telling the truth or whose evidence is deliberately misleading, I would like to address it, but I'm not sure if that's the deliberate intent of what was written. So I just want to bring that up. And I'm going to give an example of what I would talk about is what I understand to be reliability. The county, I think, is trying to suggest that, or submits that there's evidence that is more or less reliable. Evidence that is hearsay based entirely on another person who is not present and that cannot be tested in our submission is of, we argue generally as legal counsel that that evidence ought to be given no weight or very little weight because it's not reliable and it can't be subjected to cross-examination. It can't be subjected to testing, and there's no ability to really contradict it because it's just laying out there. I think each of the parties have made those kinds of representations with respect to some of the other evidence by the other party, and we accept that. But I just want to make sure that when we're talking about credibility, if there is a challenge to someone being honest or not, we should probably be more explicit about that. The county is not suggesting that there are any witnesses for the town that came forward and we believe that they were deliberately dishonest. We have made submissions about whether or not there was a partiality, and particularly, I think that feeds into some of the suggestions that we've made about the reliability of certain kinds of evidence. And I'm going to give an example. So Mr. Tim Shushin entered a couple of statements. One was with respect to police and ancillary services to the police service by the RCMP. And then the other was with respect to fire. And there was an issue raised with respect to various paragraphs in Mr. Tim Shushin's statement on fire, where he relies, and through cross-examination, it became very clear that he relies exclusively on somebody else's representations to him, which in themselves have not been tested and are respectfully unreliable. And they should not be given any weight whatsoever. And I'm speaking in particular, but not exclusively, about the representations that were sourced back to Brian Wynn, the fire chief for the Whitecourt Fire Department. So that's one example where we would say reliability is the correct term. The evidence isn't reliable because it's somebody else's evidence and it's at least double hearsay. But at best, it might be more than that, more hearsay than that. And what we have, for example, is, I'll just use one specific example, Mr. Tim Shushin saying, representations about the training of Woodlands County firefighters when he admitted on cross-examination that he has no knowledge of the training. And similarly, Trent West, the expert for the town, had no knowledge of the training provided. So any evidence they might have given about what training is provided to Woodlands County volunteer firefighters isn't reliable. You can't rely on it. Similarly, I think the word uncontroverted and uncontested, I think we have used that term where evidence was put forward by a witness and either there was no cross-examination, for example, in the case of Alicia Bourbeau, her evidence wasn't cross-examined upon, so it is uncontroverted. and it can go in on that basis. Where somebody was cross-examined and contrary evidence or evidence that clarifies their written statement, which was their direct evidence, that evidence is contested regardless of whether there's a responding witness statement put in. And I think it's important for us to all remember that those are pieces that matter here. And so to the extent that the submissions make sweeping statements about whether evidence was uncontested or uncontroverted, I think it's important to go back and confirm whether in fact a witness was cross-examined. And every witness was cross-examined that put forward a direct witness statement, but for Ms. Bourbeau, the corporate services director for the county. And there were representations made about producing Mr. Wynn, and we're going to apologize in advance for forgetting the name of the individual from the library board for the Whitecourt Library Board. But that individual was also, I think it might be LaPointe, but I'm guessing. So in any event, those two individuals, the town held out that they would make those individuals available. Mr. Wynn was not put forward even when I requested it, and then later was going to be put forward, but we'd already established that there was nothing in Mr. Tim Shushan's statement that was really sourced back to Mr. Wynn that could be tested. So I'm asking that the arbitrator disregard all of those statements as inherently unreliable, and also in some cases personalizing and inappropriate, but that just goes to the fact of whether there was a partiality. And so once again, I would say the evidence is unreliable, ought to be given little to no weight. Evidence also can or cannot be probative. And I think it's important when considering the evidence that was given, whether or not the evidence provides facts that allow you to make a determination of something that's in dispute. To the extent that lay witnesses, as distinct from expert witnesses, told stories, gave opinions that were not founded in some level of professional expertise, or were simply providing an argument fashioned as a statement, those things, again, are not evidence, and they should not be relied upon as though they're evidence. I'll give an example. Mr. Smill's general evidence statement had a number of position statements that on cross-examination, Mr. Smill correctly, and I think respectfully, I would say correctly, acknowledged to be the town's perspective, or maybe also the town and Mr. Smill's perspective, but certainly he was speaking on behalf of the town. And that is an opinion dressed up as a perspective, but it's not evidence. It's just a lens. And to the extent that those things also occur in the county's witness statements, I would respectfully acknowledge that those are also perspectives. Mr. Ward described yesterday that was simply to sort of give some context to the evidence. I think we had a discussion early on about procedure, and we had agreed that we were not going to put anything but facts in the witness statements. I'm not going to revisit that, but I just wanted to make some observations about evidence, even though I understand and the county respects that you are not bound by the rules of evidence specifically, or the Alberta Evidence Act per se, but you are bound by, and arbitrators generally are required to proceed in a manner that is procedurally fair and accords with principles of natural justice. And so I raise these points really to say, perhaps a reminder to all of us that care ought to be taken with terms used to characterize evidence, and we should say what we mean. With respect to specifically some of the evidence that was put forward, and I think that representations that have been made by our friends on behalf of the town, there was much ado made about Gordon Frank's evidence with respect to fire. And I think there is a fine line here. Mr. Frank did provide some statements, and Mr. Frank is not a fire authority. However, Mr. Frank referenced the fact And it is an evidence that is uncontroverted in the sense that on cross-examination, it was upheld, that Mr. Frank had a history for many, many years across multiple municipalities of being responsible for the not personally delivering fire services, but administering that as an administrative authority within those municipalities. We heard from Mr. West that if you didn't show up for a meeting, you might be named fire chief. When I asked the question about whether NFPA 1021, which is what I'll call the leadership training, if that I asked the question, is that something that you absolutely can't live without in running a fire department? And Mr. West made the joke, but the factual statement that in the past, where we all started was to say, if you didn't show up, that's the position you were given. Meaning, of course, you didn't have to have that to run a fire department. And I don't mean in any way to demean Mr. Frank. I'm just going to say Mr. Frank was nominated for that role in those municipalities that he operated in. And he spoke from that level of professional experience, even if he's not an expert in fire service delivery or the fixing of fire service levels. He was an authority in the municipalities in which he had that role. And I will remind everyone here that there was no manager of protective services at Woodlands County until March of this year. And so that the responsibility to execute on county council's directions with respect to fire service levels and the administration of fire and protective services did fall to other people within that municipality. And at periods of time that would have been within a role that Mr. Frank held. To the extent he gave observations in that regard, those would have been observations and may have come across as opinion, and they may well be lay opinion, but their lay opinion, I didn't cite this case because I didn't think this was going to be the issue that it's become, but there's a case called Con Construction with a K. I can provide a copy to everybody if it's helpful to you or to my friends, Ms. Ward, and we can do that before tomorrow as well. But there's essentially, if I may really colloquially summarize the critical piece of that case, there are people that work within, for example, if I use the municipal government example, municipal governments have individuals with relative expertise that speak from a position of authority about the roles they have. Ms. Barney and Ms. Borbo are those kinds of people. They would be what I tend to call indoor experts, meaning people within your organization who don't have a degree of impartiality because they are employed there, but they do have a degree of precision, accuracy, and expertise that an expert would have. The added layer that a Mr. James Richardson or a Ms. Colette Miller or a Mr. Trent West or Mr. Adam Martin might have is that they are outside of those organizations, so they have a degree of impartiality that lends itself to reliability and credibility. And it's not to say that because you have expertise within your existing role that you don't have information that may be of value to an arbitrator in a municipal government arbitration. And that is the manner in which the evidence with respect to fire from Mr. Frank's perspective was provided. To the extent it was contradicted by other evidence, we leave it to you, Ms. Howes, to decide what evidence gets the appropriate weight. I just wanted to sort of provide a point of fairness. I don't think the same is true necessarily. I think Mr. Smill clearly spoke with a position of authority as the town's and as did Mr. Frank, respectfully and on behalf of each of their municipalities in their respective roles as chief administrative officers, they had evidence to provide that is to assist you in making a decision here. Where they ventured, or where Mr. Smill in particular in his statement, and I tried to point it out, ventured into a narrative that was really about painting a picture that said, these parties got along very well. It was all kumbaya until the economy tanked and then things fell apart, number one, the county would say that's not factually accurate. Number two, I would say that's not evidence. And so what I would ask, when you're looking at all of the evidence in its totality, and I don't envy your job in this regard, it is a big job, but we are grateful that you're doing it. And what I would ask is that you consider what is the most cogent evidence from the various credible sources that you have. The experts are there to assist you, and we all observed you making use of that and asking them questions. And they're there to assist you with that lens of impartiality, I would submit. And I don't think anybody contested that about any of the experts. Mr. West, I asked whether he was straying into an area in which he was not an expert, and he readily acknowledged that, as a good expert ought to. Otherwise, I think the experts spoke about what they were experts at. There are other witnesses who gave you evidence that I think is cogent in that it's reliable and it's factual and you can verify it against other things. There is other things that were put in evidence before you that I would argue are not necessarily as reliable. And we would ask that when you're considering the merits of positions, that you look at what is the most cogent evidence and you make your findings based on that. As an example of cogent evidence, we would say something with a high degree of reliability elevates and impartiality elevates the level of what I'll call cogency. So for example, when you have before you submissions, expert opinion evidence from Mr. Richardson on the administrative overhead approach being appropriate, that's taken in the context of how it was delivered, which was, we reviewed this approach that's been outlined by Ms. Barney. It looks appropriate to us. We did no testing, no assurance testing of it. And then we had, and you also had evidence from Mr. Richardson that that was one means of apportioning costs. It was not the only means, and he didn't say it was the best means. He acknowledged that the representations about best were specific to Alberta environment in the document that was relied on by Ms. Barney in her witness statement, and was the source for the town, sorry, I'll back up. The town applied a portion of the approach that's outlined by Alberta Environment in that, I think it's 2011 or 2012 water full cost accounting program. You also had evidence that is cogent from an expert in municipal government accounting and auditing, Colette Miller. And Ms. Miller gave evidence about some concerns she had with respect to administrative overhead as it's being put forward here as a means of calculating cost share and apportioning costs. And I'll get to that a little bit later under one of the other subject matters. But just to talk about the cogency of evidence, that evidence is what we would normally say as lawyers on the highest end of the spectrum in terms of cogency, reliability, and credibility, because of the fact that it comes from outsiders, they're third parties, they have expertise in the subject matter, they are subject matter experts, and they're speaking from that position. And their evidence was subject to testing. We all got to ask them questions. There's also an issue about where there is and is not evidence. The town has put forward items for determination to be included or excluded as cost shared services within the ICF. And on some of those areas, the only evidence before you of a benefit appears to be the county paid for it in the past. And I would submit that that is not, it's on the lowest end of the spectrum apart from the double or triple hearsay. Evidence that somebody paid for a service or a good in the past does, when the current provisions of the Municipal Government Act, the ICF provisions, were not in place does not enable you as the decision maker for these parties to avoid having to do the analysis of whether or not there is in fact a benefit and whether the other criteria that are applicable to determining what is and is not an intermunicipal service apply. And so that's the job that you have before you. And on the issue of whether or not something is a benefit, the fact that parties contracted for it doesn't alter the obligation to do the analysis of whether or not there's actually a demonstrable benefit to the residents of the other municipality. And I think we'll get into the detail about the fact that even where a benefit may have been agreed upon in the past, it doesn't alter whether or not there is an obligation to continue sharing in that service if there isn't a proportionate benefit to the contribution that's being sought. And or what is the amount that ought to be paid for a service that has modest or very little demonstrable benefit. On that note, I think we would say that where the town has relied on the fact that they delivered services, for example, recreation services or FCSS services in the past, and they say, we don't have very reliable evidence about the benefit to the residents of the county to show you that they should be paying their fair share and to quantify what that fair share is. And instead, they're asking you to incorporate into your decision, the AUMA guidelines around catchment areas. We would say that the evidence there, to the extent that there's evidence, for example, in FCSS, of very few enumerated county residents, the percentage is remarkably low in the records that the town has kept. And I think one of the pieces of evidence you need to consider is the obligation the town has always had to be able to demonstrate a benefit to the county, even if that wasn't spelled out in specific terms in the legislation. Under the terms of the parties' contracts, and they were contracts at law, the consideration that was to flow in accordance with contract principles from the town to the county were benefits to residents. And that's still the case under the ICF principles. And where the parties can't agree on those benefits, it has fallen to you in this particular case to decide whether they exist. And the county would say, we acknowledge the benefits for certain services within the recreation department. And the county has said, we're prepared to include those in an ICF and to pay for those services, because we acknowledge that they provide a benefit, notwithstanding the failing on the part of the town to provide credible and reliable and cogent evidence about the actual benefit. But to the extent that there's an extrapolation to say, number one, if I just speak really specifically about the evidence that Ms. Grande gave, Ms. Grande said a number of different things about why the town did not have proper evidence of who was using its services. An inference ought to be drawn against the town for failing to have been accountable to the county in compiling and reporting on actual benefits. So to the extent that they're now asking for the county to contribute to every imaginable recreation service and facility, there ought to be some means of measuring what benefit there actually is. And I think here we cross the line into the municipal center to some extent, where a similar argument is being advanced that there should be a contribution from the county to the town for the municipal center. There should be a contribution writ large from the county to the town for recreation services, regardless of whether or not we can demonstrate an actual service received by residents of the county. And you should instead assume that the rings on the map put forward from the principles by the Urban Municipalities Association governs your decision in that regard and is good evidence. One of the other things that the town is asking for is that you expand the scope of the recreation services and some other services to almost all, or in the case of the municipal center, all of the electoral districts within the county. I have a few points on that about where's the evidence. And number one, I'm going to make a note for everybody that isn't already aware of this. The electoral districts are being reviewed by the federal government, are in the process of being revised. That began this month, I believe, September of 2021. So they're going to be in flux. We don't know where those will land. I'm not sure that's the most reliable way to apportion cost contributions, given that fact that almost certainly within the term of whatever the term of this ICF is going to be, those things may change. Secondly, the very fact that the town is now asking you not only to grandfather all the things that they received contributions for under the old agreements, but to expand that scope, and specifically to expand the scope of recreation services to people who are closer to an hour away than they are to 20 minutes away. The town is asking you to make a finding that there's a benefit that's to be presumed based on driving times alone. And respectfully, I think that might be true for services that are not at all located anywhere else within the county, like the pool, the indoor pool. And even though there is an indoor arena as Fort Assiniboine, it is a considerable distance from Fort Assiniboine to the town. And the county concedes that there's still value for all of the various reasons that I think there are value in things like the twin arenas in the town. And so they are prepared to contribute to those items, recognizing, number one, they're costly to maintain. Number two, they provide a benefit. And that benefit might have a greater reach than something like a Zumba class, which is available and funded, as you see from the evidence in Ms. Anderson's statement for FCSS and Ms. Kennedy's statement for recreation for the county. There are numerous programs and facilities within the county. And to cop a phrase used by Ms. Miller, what's sauce for the goose is sauce for the gander. And if there is programming, if there is a commercial campground in the town that allegedly negates any onus on the town to pay towards the group campground, which is a separate thing than just a campground. There's a group campground run by the county, paid for, maintained by the county, serviced in that regard, but for the telephone bookings that are done through the Visitor Information Center. If all that the town needs to do to convince you to disregard any contribution it owes for that service is to say, what is a commercial campground in town? That same reality ought to apply to every recreation service that's delivered by the town, that is available through every community center in other districts. And the other piece of that reality of proving who you're serving is that it was acknowledged even by Mr. Smill that people who live in Anselmo or Blue Ridge would also be likely to attend and use services from the municipality that is the urban municipality that is closer to them, being Whitecourt. Further, with respect to Goose Lake is closer, so that's Region 6, Electoral District 6. Goose Lake is closer to Fort Assiniboine or residents in that area in some parts are closer to Fort Assiniboine than they are to the town. expanding to that region, given where its geography is in relation to the town, is questionable. And I think that I would just encourage, you as a decision maker here to look at that geography. I think the question that you asked yesterday of our friends with respect to the library in Blue Ridge, the county library in Blue Ridge, the same analysis ought to apply for recreation services. And to some extent, as I understand the town's argument, I think we have to look at the evidence as, is the town really saying that its recreation services, much like its municipal center that it is looking to build, are those services really regional services? And if they're regional services, do they belong in the ICF at all? And to the extent that the town is saying all of the county ought to be responsible for contributing to the municipal center cost share, which is resisted by the county. But even to the extent that that's the argument, the only evidence there is the statement that it will provide, because it does nothing currently, it will provide something unique to the entire region. And Ms. Grande conceded that essentially it would mean that those services are allegedly of regional benefit and not merely intermunicipal services. And so to that extent, they may or may not fit within an ICF, to the extent that the cost share that's being proposed is asking the county to pay for services that are, by the town's own evidence, arguably almost certainly used by other municipalities without any effort by the town to collect from those municipalities for the benefits that their residents are receiving. And there, I think there is an accountability factor, as the accountability factor was defined by Mr. Richardson, that would say the town bears the onus of that accountability and tracking, and ought to be encouraged in this ICF arbitration process to do proper tracking of who is actually using its service, who is using those programs, who has memberships. I would argue that it is not. There is a question about the air of reality to the suggestion that you cannot break out who's a member in the town's evidence from who simply used a program or enrolled in a program or used a service one time. The evidence about who's a user ought to be given as well relatively little weight, to the extent that there's an attribution to residents of Woodlands County that are not actually available on the record. To the extent that we're relying on post office information, where somebody defines themselves as being a Woodlands County resident, I think you can reliably, we accept that that's reliable evidence that they're a Woodlands County resident. Where there's speculation about that by a postal person who wasn't even put forward to be examined in evidence, that evidence isn't reliable, and it shouldn't be given much weight, if any at all. The catchment area principles, similarly, that are set out in the AUMA guidelines, or the documents that were relied upon by the town, those catchment area principles are ways that the recommendations there appear to be ways in which municipalities can agree how they're going to break out who is benefiting. Where it's not agreed, the decision comes to you. And I think we're asking that if that's the best evidence, it ought to be viewed with some scrutiny when the balancing of that is historically, in the most recent years, $1 million item. So if we're looking at, and it looks to me that there's now a $1 million plus system being proposed by the town. So there's the admin overhead, the life cycle plan, plus the cost of delivering the service outside of the administrative overhead. Particular services, to the extent that there's an ask for $1 million or more for recreation services writ large, I think some serious scrutiny needs to be paid to the catchment area principle. It cannot simply be relied on as as though it were agreed to by the county, because the county does not agree. And to the extent that involuntarily there's a request to expand the service area, we would say the service area ought to be demonstrably beneficial. And the further those rings get away from the center, we would ask that you weigh with some trepidation the actual service and what cost ought to be apportioned to the residents of those areas that are farther and farther away from the town. In short, I think we're saying the we say so principle is not reliable evidence. There has to be something better than that. And what has been offered to you are catchment areas based on guidance from an urban municipality association. And one would hope there's something more principled than that, and that there's an accountability factor built into the go forward ICF in that regard. That cannot be the full disclosure obligation, that we don't have any obligation to track who's actually using our service and what the actual benefit is. I think there's also some questions, and I'm not going to have time to go through every single one of them, but there are some issues with respect to the evidence that has been recited in the written submissions and to some extent replicated in the oral submissions from our friends. And where they're inaccurate, I will try to highlight some of them. Where those inaccuracies have come into play, I assume that those are inaccuracies that are inadvertent, but they're nevertheless inaccuracies. And so we just want to clarify some of those things on the record to make sure that there isn't an inadvertent misleading of you as the decision maker. And one of those, sorry, I don't know whose dog that is. I can confirm there are no dogs allowed in our building, but apparently there's a dog nearby nonetheless. The town is asking for administrative overhead. And the evidence of that is really limited to two things. Number one, it's limited to Ms. Barney's calculation and her stake setting that out as to what those amounts are. There is no full and transparent disclosure of what's been included. There's been very high level representation in that regard. But the evidence there is limited, and that was noted by Ms. Miller in her oral evidence. And I think the other evidence on that point is Ms. Grande provided some information about what was included in administrative overhead with respect to recreation and FCSS. And what's excluded from there are the costs of her remuneration and benefits, so her compensation and possibly others. But that entire salary we heard from Ms. Barney and then also from Ms. Grande is attributed to the cost of delivering the services. And what administrative overhead essentially amounts to, notwithstanding the representations by our friends, is the county being asked to pay for its own overhead in delivering services, as well as a substantial portion of the administrative overhead of the town. And by substantial, the number in Ms. Barney's statement is over 33%. So 1/3 of all of the administrative overhead costs to run the town, the county is being asked to pay. A more perhaps colloquial characterization of that evidence would be that the town is asking the county to subsidize its operations and dressing it up as a cost share for service delivery. In that regard, we would say that the most cogent evidence you have before you with respect to administrative overhead and why it's a bad idea is from Ms. Miller. And she came at that from a number of different perspectives. She raised concerns about the encroachment and inconsistency between two autonomous entities. She talked about the two municipalities, the county and the town here, being autonomous entities. They're two different business creatures. That's true under the statute, under the MGA. They are each a municipal corporation. And each of the parties in cross-examining the other party's witnesses has sought and obtained admissions that these municipalities are independent, and they are each required by statute and delegated the authority by the legislature to make decisions about what services are available, what service level is to be provided, and what service area those services are to be provided in. Each municipality runs itself differently. That was the evidence of Ms. Miller, as any two businesses would. And I believe she gave the analogy to Mr. Ward's law firm versus my law firm, or Ms. O'Kelly and my law firm, that we're each going to run our business in our own way. And adding administrative overhead into a cost share means that to the extent that the municipalities aren't calculating things the exact same way, there's an inequity in what she described as an irreconcilable difference. That's trouble that can be avoided by not implementing that method. The other concerns that Ms. Miller noted that I think are important are one comment in her first written opinion was the potential, what I'll call mischief, the possibility of manipulating numbers was her exact phrase. In her oral evidence, she spoke about the administrative burden. And I think, Ms. Howes, you asked questions about that, both of Mr. Richardson and of Ms. Miller, with respect to when a municipality wants to use a complicated way of calculating what the contribution ought to be, who should pay for that? Who should pay for it on the end of the party that's delivering that information? Who should pay for the cost to the other municipality and trying to decipher it? That can be avoided. And to that end, this goes to the county's request for a fixed amount as opposed to the moving target or the cost and resourcing required to review. It also provides certainty to a municipal council who doesn't need to get into the weeds in that regard, as Ms. Miller noted. One of the other concerns she raised was a concern that all of the information that's been provided historically is not tied back, and it's not clear that any of the information that is to be provided, since the suggestion is that the process follow more or less the same method that was followed before. And none of that information is tied back to the audited financial statements, which, as Ms. Miller said, and I quote, means there's no assurance over any of it. And each of these municipalities have a duty to be accountable, as Mr. Richardson noted in his opinion, and Ms. Miller agreed with. And part of that accountability is that issue of what is money being spent on, and is there value for what we're paying? And the assurance piece, if it's to be done as part of a cost share, adds a layer of cost that I would submit respectfully, and the county submits respectfully, is not commensurate. And it's avoidable. There's other ways. It's one way, not the best way. To repeat Mr. Richardson, it isn't necessarily the best way, and it's most certainly not the only way. The comment that Ms. Miller made, and I'll quote it, the suggestion was that there's a challenge to the municipality's autonomy. She said her third concern was going back to running your business. She gave the example, if the town decides that they need administrative overhead for people to run their fire department, and the county decides we could do that with only 2 people, all of a sudden you have introduced a layer of detail and a lack of autonomy in those decisions. And she described that as an irreconcilable difference. One of the areas where I think we have evidence that, for example, a simple example, and it's probably not material to your decision, but just to illustrate the point, Mr. Tim Shishin gave evidence that volunteers for the Whitecourt Fire Department do not participate in delivering service until they're fully trained. Mr. West clarified that, saying he hadn't checked in on this fact, but generally speaking, that's not how volunteer firefighting works. You have a basic level of training that's absolutely required, and that's going to vary because, as Mr. West noted, there is no minimum standard for fire training for delivery of fire services in Alberta. Alberta has not adopted a minimum standard. So it comes down to what the municipality sets as a service level. And in that regard, he said ordinarily, even before a volunteer has NFPA level 1001, level 1 of 1001, they would be, you'd need the hands, you'd have them out there doing something. They would have been given some initial training for certain, but they don't have to need to have completed that 120 some hours of training before they're eligible to go out and do their first volunteer job. And that, my point there is really just to say, human beings are fallible. Mr. Tim Shishin is speaking about 2 service areas, and he's an administrator. He's imperfect, just like in the same way that the imperfection has been repeatedly raised with you about Mr. Frank, giving evidence that isn't necessarily the same evidence as Mr. Webb gave for the county or Mr. West gave as an expert on fire, specifically with respect to the town. So just to round out my comments on evidence, I will just say that I'm not suggesting that you take the evidence with a grain of salt, but I think that you acknowledge the human imperfection in the human being and accept that people are doing their best when they're putting their evidence forward, and that no nefarious intent comes from that or is drawn from that. With respect to the third theme, oh, sorry, I'm just noting that it's 11:43 and I've forgotten to notice the time before now. I know we usually take lunch somewhere between now and, or between 11:30 and now, and I'm happy to move on to my next item if you'd like and get started, or to stop and have lunch. I'm in your hands, Ms. House.
I think we'll take the lunch break at this time, so we'll come back at 12:15. Whenever you're ready, Ms. Roberts.
Sorry. Thank you, Ms. House. I just have like a quick little points about the evidence piece. I was going to mention just a few things about there being no evidence for some of the principles that are, or the submissions that were made. They're small points, but I just think it's important to point them out. In one instance, we have submissions in writing and in oral submissions from the town with respect to what are being called police services. And I think that's because for the most part, they are services delivered by RCMP officers. But the representation is that there's a cost contribution that's being requested from the town on the basis that there's a cost to the town, both under the lease and some other things. We'll rely on our written submissions with respect to those pieces, but just to address some factual inaccuracies or absent evidence. There's a representation in paragraph 13A of the police statement put forward by Mr. Tim Shishin on behalf of the town. And the references to the community liaison, the paragraph reads RCMP school resource officer / community liaison. And Ms. O'Kelly, in cross-examining Mr. Tim Shishin, asked whether that individual was an RCMP officer, and the answer was yes. But the submissions that have been made on behalf of the town suggest that the community liaison officer is something that the town is paying for or that requires a cost contribution for, notwithstanding the fact that it is an RCMP officer, not a town employee. There's also a reference to an FTE position. I'm not speaking with respect to that. I'm speaking specifically to the representations about the community liaison. So if the factual reality is that that's a position that was created when there were cost sharing for police services between the town and the county, it's up to the town to decide whether or not it wants to continue to fund that. The representation in the witness statement from Mr. Tim Shishin, without any substantiation whatsoever, is that both the town and the county benefit from the services that are delivered. But there's no evidence of whether or not the county uses these services at all, and to what level. And so I think it's notable that we have a reference specifically in the submissions yesterday, orally, there was a representation that services for example, vulnerable sector or fingerprinting, I think it was vulnerable sector, were not offered anywhere else in the county, but I can't find that in evidence at all. And it may be a minor point, but I think it's important. It's important to note that unless that does appear somewhere in the evidence, and I've simply been unable to find it, that we not make statements to you as statements of fact if they're not in fact borne out by the evidence. I think it's also important that we accurately convey what the evidence really says. I'm gonna ask that Ms. Antler please pull up the Municipal Center witness statement of Chelsea Grande. And specifically, sorry, I just need to find the page that I had.
37. Was it 37? 37?
I think we're going to page 37. There's a representation. There's a representation at paragraph 208, or sorry, paragraph 218 on page 110 of the town's written submissions. And it was reiterated yesterday in oral argument. And the reference there is that 42% of respondents to a survey were highly likely to use a performing arts facility. But if we look at paragraph, and it's in, that comes from Ms. Grande's statement, but it's referring to this page that we have in front of us, page 37. And if we look at what's actually asked and answered in that question, the question is, in the past 12 months, have any members of your household participated in or been a spectator of any of the following arts-related activities. And if we, in particular, I think we need to look at music lessons or performance and dance lessons or performance. And those two numbers are 24% and 36% of respondents. So at the end of the day, the amount, the 42%, is comprised in part of information about people's kids attending dance classes potentially, or music lessons, or themselves, individuals, the residents themselves doing so. And I don't think it's fair to translate that, or accurate to translate that into saying 42% were likely to use the performing arts facility that the town now wants to build, and that somehow that's probative of what you should find to be something that is a likely benefit. In other instances, as I mentioned with the police, there's no evidence whatsoever of the use that's being represented in the bold statement of fact. And I think that has to factor into what apportionment, if any, for cost contributions ought to be made by a municipality that's being asked to contribute to something where the evidence just doesn't exist or is not accurately represented before you. To move on from that, the third theme that we were going to discuss was certainty. And the county, in its fiscal stewardship request to put that issue on the agenda for the arbitration, in part was addressing that. The fiscal stewardship piece is about certainty in terms of the ability to plan. The town and the county, as summarized by Ms. Miller in her evidence, orally as well as in writing, are not in the same fiscal position. Although Ms. Miller made an assumption in her evidence orally about the impact of the economic downturn on the town being substantial, as well as it was on the county, the evidence on that we have is Mr. Snell's evidence. And Mr. Snell's evidence is that the impact was not of the same impact. The impact was not of the same significance on the town as the county. And part of that, Mr. Snell ties back to the fact that the very fact that there were properties in the county on which taxes weren't paid, for example. So there's a loss of revenue. You heard in evidence, and I think in response in part to one of your questions, Ms. Howes, that the expectation and the obligation on the part of the county under the previous cost share agreement was to continue to pay revenue sharing even after the economic downturn, even after 2014 for numerous years. And 2014 was the year that Mr. Snell argued was when there was a change, or that the town, rather, in its written submissions, says is the turning point financially. But in fact, the county continued to pay hundreds of thousands of dollars to the town in revenue sharing. It's linear tax revenue sharing. It's tax revenue sharing under the cost share agreement, the amended cost share agreement, and it paid that amount right through until it terminated its revenue sharing agreement. And there was no flexibility. And if we review Mr. Snell's statements and the opinions or perspectives of the town set out in that statement and referred to in the evidence on cross-examination, just to confirm that was the town's perspective, those statements demonstrate that there is a continued expectation by the town, and that is also demonstrated in the submissions in writing and the oral submissions yesterday. The expectation from the town is the county, thou shalt continue to pay, not only at the same rate that you were struggling with before, but at an even higher rate. That is the request that is before you. And then a question is raised about the bona fides of the county's commitment to a collaboration. And I think all of this leads to the fourth theme that I'll get to later about equitable and equitability. But right now, I think what it begs of of you is to lay down some rules that make the relationship and the obligations flowing between these parties sufficiently certain that they can follow through on the ICF for the duration of time that it exists without further dispute of that nature. And the reason that we ask again for the force majeure clause is not only to say if the county has, for example, had we had a force majeure clause, there's every possibility that the county could have sought some relief pursuant to that provision and possibly not ended up in this arbitration. And so to forecast into the future, I don't mean to be spellbinding, but just to say, I think it's fair to also say that if the parties had some event that wasn't, as Ms. Miller put it, funded by disaster relief, essentially, that you are eligible to apply for, when the examples Ms. Miller gave were, I think, the Slave Lake and Fort McMurray fires. We can also talk about flooding that's happened in the province in recent years. Those things happen. The economic downturn and the impact on Woodlands County was what it was, and there were certain consequences of that flowed and are continuing to flow. The county is working to rectify that and overcome it, but it's some years away from being back in a position where the county itself can contribute to its own capital reserves. Ms. Miller gave evidence about that. In response to one of your questions, Ms. Howes, about what Ms. Miller was getting at in her summary of financial circumstances in her first report, she commented on the fact that the town's position in terms of cash in the bank and then going back to a question from Mr. Ward about reserves was a strong position, and that the county's position, conversely, was, number one, it was on a watch list, but it was on a watch list because its key performance indicators or financial indicators were such that it was not able to replace. Among the other things Ms. Miller commented on was that the county was not in a position to be replacing its own capital assets as fast as they were depreciating. And that was an indicator of a not financially strong position. And that was the disparity between these two parties. And one of the things that we're looking for with the certainty provision is to address the practical reality that is, at least for the next few years of foreseeable future, part of the county's experience. Even if they wanted to continue to contribute to the intermunicipal servicing, to the extent that the services are in fact intermunicipal services, asking it to do so in a way that contributes to the revenue sharing and maintains the cost at the previous level, that in and of itself may or may not be doable, and we don't have evidence on that. But what we can say for certain is that there's a question about the equitability of expanding that without having a comparable level of evidence to substantiate it. And I would submit respectfully, you do not have the level of reliable evidence that's probative for you to be able to say that the expansion that's being sought with respect to, for example, recreation services and the new service areas that the town is asking to be put in place, and it's not conceded that they're service areas, but let's call them that for the purposes of these submissions. The additional services being things like the rail, transit. In addition, there's the library. There are things within recreation that are consistent with the library and the police services, the library and the transit, and some of the other services I'll go through at the end briefly and touch on each of those. But we would say, as we did in our interim submissions on our application, which you declined to grant, to exclude some of that evidence on the basis that those were not properly intermunicipally delivered services. We are asking you to make findings in that regard, and so is the town. And we're submitting that those services are either not properly the subject of the ICF that we require your assistance with, Or there's been no intermunicipal benefit, i.e. a benefit to county residents that's been demonstrated on the evidence. If I use transit as an example, going back to the principle of evidence, there is precious little evidence. Mr. Ward referred to there being 17% of people that came from the county. I think the creative accounting that occurred with the Postal Service data, the creative accounting that happened with the Postal Service data for FCSS and recreation, it's similarly problematic with respect to transit. And if we look at the actual numbers on transit, those numbers, and from the cross-examination of Ms. Grande, those numbers are incredibly small. And the most telling feature is that the transit service is only delivered within the town's boundaries. And there's evidence within Ms. Anderson's statement that there's other services that are provided respecting intermunicipal transit to which the county already contributes that are clearly intermunicipal, including some seniors transportation with Mayerthorpe, for example. And I would just refer you to Ms. Anderson's evidence in that regard. We don't get there on transit. And so part of the request for certainty here, it goes across issues of time, so the duration of the agreement, and what are the parameters around time. The county is requesting that there be an actual date that this is concluded or must be extended, not a review period that becomes extended because the parties can't agree. A review period only works if it's enforceable. And generally speaking, in intermunicipal agreements, those things are agreements to review. We don't want an agreement to agree. We would like some clear guidance to the parties. With respect to certainty of cost, that goes to the fiscal stewardship piece and the ability for the county to continue on its path toward economic recovery so that it can, if the municipalities, these two municipalities so choose, be a contributing member of an intermunicipal collaboration framework, should they be able to reach those agreements in the future. At the moment, expanding the scope of the ICF for these two parties in the face of the abundant evidence that is reliable and is probative of the county's financial circumstances would not be equitable, and leaving it uncertain would be likely to result in exercise of the dispute resolution mechanism, which would also prejudice the parties, including the county. These costs of running this arbitration, of having, but for any grant funding that the parties might be eligible to obtain, having ADR processes is costly and time consuming. So we would ask that there be sufficient certainty in the agreement to address those issues. And I think each of the parties have made representations and submissions about the importance of a dispute mechanism. There is some interest, I think, on the part of the parties through their council to have further discussions in that regard, and if invited by yourself, to make further submissions with respect to what might go into a dispute resolution mechanism. And I would ask respectfully on behalf of the county that that opportunity be made available. In this particular case, a boilerplate dispute resolution provision is not necessarily going to be what these parties need. There is a dispute resolution request with respect to fire services in the town submission. The county adamantly opposes that. It is the first time that I have heard of that was in the written submissions, and then reiterated yesterday in oral submissions. No evidence was led about the dispute resolution mechanism requiring 3 fire chiefs. I think there's a serious problem with that possibility, in the sense that if one of the things that's an issue is a governance question, fire chiefs are just that. They're experts in fire service delivery and administration. They are not members of council necessarily, and they do not have hats outside of fire per se. And I think that is not the appropriate mechanism. The mechanism should be, the mechanism for the dispute resolution should be adequately certain that it can be applied to any dispute and not earmarked for a certain kind of special treatment that at the end of the day may yield an outcome that is inconsistent with the ICF as a whole and may only focus on something that is very subject matter specific. If further clarity on that submission is required, we are prepared to provide follow-up submissions in that regard. I have not had an opportunity to address it in writing, and neither has Ms. O'Kelly, because we just didn't know about it before. And I appreciate that may be something that came to light for the town at the end of preparing their submissions as well. I'm not criticizing my friends at all. I'm just saying we just haven't had time to put anything substantive in writing or rely on any authorities to raise our concerns about that particular carve out on the dispute resolution. What the county would ask for is that there be robust provisions around dispute resolution that apply to disputes. And I think it would also benefit, I think, both parties to have a mechanism that can be used for what I'll call to smaller scale disputes as opposed to larger scale disputes. And so I think there's some work that needs to be done there, and to the extent that the parties can be of assistance to you, I hope that we may be able to do that. With respect to the certainty of time, we've already made our pitch for a 5-year agreement. We're proposing that have a backdated start date. My understanding of the parties' agreement was that the terms of the ICF would apply back to January 1 of 2020. We now hear submissions from the town that instead there's just supposed to be some attribution of payables without actually having the parties bound by that agreement for that period of time. Again, that's novel, and so we haven't submitted anything in writing in response to that because we did a simultaneous exchange. So this is where we're addressing it. But I think that what we would typically expect in a contract would be that the parties are bound for the entire time that it applies. And so although there is a portion that would retroactively apply the cost, the services continued from prior. So to the extent that there has to be an apportionment for services that do not continue carry forward, that can be addressed, I think, in part of your award, but it doesn't mean that there shouldn't be an agreement in place for the parties. To the extent that there's a suggestion that the agreement should be 5 years starting in 2022 go forward, or the end of 2021, the county would then, I think, ask for an agreement that is only going to be 3 years in duration, so that we're not wedded for another 5 years, in the sense that, and I think in fairness, as a party to an intermunicipal agreement, there is a projection for the financial circumstances of the county should things track as planned to improve within that following 3-year period. And that is part of what informs our request for the agreement to run the January 1, 2020 to December 31, 2014 period. I think there should be an option to extend. I think what I would submit on behalf of the county, respectfully, in order to ensure that municipal government authority is exercised by the councils who are the parties that are responsible for this agreement, is that wherever there is something that may need to be altered in the future, including an option to extend the term, that should be something that has to be approved by each independent municipal council, not by a joint liaison in a form of a recommendation. I mean an actual approval by a quorum of council for the town and a quorum of council for the county, acting independently of one another. Certainly there can be a recommendation. What I'm saying is that can't be held out as being the agreement. Similarly, if there's to be an expansion or a serious reduction in contributions, if the force majeure clause is to be exercised, those are things that should involve council to the extent that there is a force majeure clause. I'm not preempting your decision, I'm just trying to be efficient. With respect to sorry, I'm just reading my notes. And so I think I've addressed kind of my points on the certainty with respect to time. I think also with respect to the certainty of cost and benefit, we're asking for findings to be made with respect to the evidence that's before you. about cost and how it should be calculated. And also with respect to benefit. And the benefit question really comes down to which services are in and which services are out, and what is the benefit within a given service area. For example, within recreation, I think there is a request for you to decide which of those services are truly intermunicipal. And if I give as an example, my friends pointed out, and it's in their written submissions as well as was yesterday recited in oral, there are numerous buildings, either existing or being proposed in the case of the municipal center, that will house, broadly speaking, recreation, arts, and culture. There's the Carlin Community Center, there's the Miller Center, and there's a third building, the name of which I forget. The Pottery Guild is in there, and I'm sorry, I forget the name of it, but it's the Arts and Culture, Arts and Crafts building within the town. Each of those three, there's a request for contribution. And I think the evidence is sparse on what the intermunicipal benefit is for some of those. There is evidence to tell you that the Carlin, the repurposing, as I think it was described by Ms. Grande, of the Carlin Community Center was a decision made exclusively by the town. And to the extent that that decision was made and then a cost share has continued to be asked, even though there's now a splitting of services across the Miller Center, the Carlin Community Center, and then if the municipal center is built, the municipal center. And in each instance, the county is, in each instance, the county is being asked, sorry, did you need me to pause? Slow down.
I'm finding that background noise really interruptive of what you're saying. And so somebody has to be able to turn off the sounds in their email system and their calendar, because I think that's what's doing it.
Okay, thank you. We
If
apologize.
you could take a moment to do that, and then we'll start again.
Sure.
Thank you.
Okay, I think we've mastered that, and apologies for that. So where I was at was saying, Ms. House, that we have a number of facilities that are operated by the town, and there's a layering of services that are provided in these different facilities, but there's a request for contribution. This is a good illustration of the problem with the administrative overhead piece, that there's all these additional costs that are being added in by having these numerous facilities. And ultimately, it really comes down to a decision about what is the service that's being provided. If it is a service, for example, that's a recreation service, the county is choosing to say, we would like to operate our own and fund through the government funding and our top-up grants, our own FCSS programs. But with respect to programs that may be at one of those facilities, the three facilities that currently exist, and there will be a fourth facility if the municipal center ultimately is constructed and operated. In each of those instances, there's a cost that's attached and being asked to be contributed to by the county. And the county has absolutely no say over how that's determined. About if the town decides to have 50 buildings and deliver services, there's going to be an added administrative overhead cost for all of that. And one of the things we're asking for with respect to certainty is the ability to foresee that and the ability to have an option to agree to it or not. And if we can't agree, to have yourself or somebody else determine it. But that there cannot be the endless new list of stuff on the list of things to be paid for. And that is partly, the county is not trying to fetter the discretion of the town to do as it wishes in delivering its services to its residents. The county is saying, we believe it to be fair, equitable, accountable, and efficient for the county to know what it's paying for, to know what that amount is going to be for a foreseeable period of time and be able to budget accordingly, so that, in part, getting back to the financial facts and the evidence of Ms. Miller, so that the county can get back on course to be in a position as it was before the economic downturn, where it is contributing to its own capital reserves and where it is replacing its capital assets as they depreciate and become due, where it is in a position perhaps down the road to negotiate terms with the town that are different than the terms that it requires currently in order to be able to get back in that position, and that also are fair and equitable to both parties. If at the end of the day, the county's real position is everybody in our general neighborhood, our vicinity, and 7 electoral districts away are benefiting from everything that, for these various things that we're providing, it begins, like I said a moment earlier, to sound a lot like regionalization and a lot less like an ICF. If those services are of benefit to parties that are 40 kilometers away, they're of benefit to parties that do not exist in Woodlands County. And that is something to be taken into consideration. And there's been, if that is in fact the case, I think we have a different set of issues to consider. But I think all of those things have to come into play about the consistency of the evidence and what are the outcomes of that evidence if you accept it for what it's put forward to represent. And what does that mean in terms of the relationship between the county and the town in administering this agreement if there is any uncertainty? And I think that's really what we're trying to say. To the extent that you are able to assist us in having certainty of terms of the agreement, we would like that to be in place. We'd like to know what we have to pay, what is it we're paying for, and what they're going to show us and tell us about what we're paying for. To the extent that the county received contributions from the town, there's a request to lower one of those, or to eliminate one of those amounts. And I'm not sure that there's any evidence before you about how the $10,000 fixed amount for both Hardlight Canyon and the group campground came to be. I'm not aware of any. I wasn't appreciating that the town was going to say it wanted to reduce that amount. So it said that now. And we'll walk through that. The reduction in the contribution for the group campground, I've already taken issue with that earlier in our argument today. But I think that more importantly, I don't know how you get to the $5,000. I don't know if it's just there's 2 items, so let's just cut it in half. And I know the town is suggesting, I think, if I understood Mr. Ward's oral representations and based on the written submissions, I think the suggestion is that because the county hasn't advocated for itself in establishing what its actual costs are, we should just saw the number in half. I would suggest that that's not the level of certainty that's required. And if not being given notice that was going to be sought to be cut out is the basis for saying that it ought to be excluded, I think a very hard look needs to be taken at the evidence the town has provided in support of the claims that it's advanced, in many cases of which the evidence is as close to nothing as one might imagine. I think the evidence of the experts is important, both to the extent that Mr. Richardson gave you a response to your question about the provision, the factor that you identified in the MGA for known as equitable. That was Ms. Miller's contribution to the list of factors. And you asked Mr. Richardson about it. His answer was important. He gave an example from his experience where the parties defined it, and he didn't really give us a definition so much as illustrating what I think the definition was, which was the parties have an item they want to share the cost of. I think it was a swimming pool. They go and figure out what their benefit is to each of them, and they go then and do the math on apportioning the costs. And that, we would agree, is a fair definition of equitable. And to do that, to get to the issue of what the benefit is, we're submitting that we think you need something better than just a catchment area. And if we're going to use a catchment area model because it's the best thing we've got, the catchment model we would submit should be the catchment model for the Whitecourt Fire District, because that is determined on the people who are most proximate to the town and who, on a what we would call in law prima facie basis, would, at least on the face of it, appear to have the greatest likelihood of having a benefit. And so if the model, if you find that the best thing you could do is come up with a region, we see no reason to expand the region beyond what was previously contributed for under the Whitecourt Fire Department. That is a respectable region, and it can apply to the go forward ICF, where cost contributions are for residents that are in those locations. The other piece about the certainty theme there is that it alleviates your responsibility to weigh in about what happens when the electoral districts change. Because right now that is a problem that is nobody's creation that's here at the table, but it is a problem. It's a problem in the sense that we don't know what that's going to look like and what that will do to your decision, and what if you rely on electoral districts in the ICF provisions that you put to us to have in our agreement, what happens when those change, if those change during the course of that agreement. And what we would say instead is, to the extent that there's a clearly delineated geographic area in the Whitecourt Fire District. Oh, Ms. O'Kelly is pointing out to me that the review is required in 2022 of the electoral districts. I might have misspoken. I thought it was this year. So in any event, it will be during the course, I hope, of whatever this agreement will be, the term of the agreement, whatever that term may be, it will occur during that period. It's supposed to happen next year. Oh, okay, so I wasn't completely wrong. I'm just going to read this off of a record that Ms. O'Kelly has passed over. There is on Elections Canada, the elections.ca website. I'm happy to share this at a break. The federal redistribution process for reviewing the electoral districts happens every 10 years. It's starting September 2021. It's supposed to be completed, by September 2023. So just factually speaking there. And I think what that means is just there's an uncertainty that's created with that we would like to avoid in our proposal, is that we have the same district for fire and for recreation and any other services if you're inclined to put any other services in there. That will not, I don't believe, conflict with the water wastewater servicing either. Excuse me. Also, with respect to certainty, again, we were talking a little bit about the capital contributions for fire. As I mentioned, the county would like to be able to maintain its own equipment. That allows it to be able to be nimble in terms of using that equipment, whether it's stored at the Whitecourt Fire Hall, or if that space is needed by the Whitecourt Fire Department, that it can be stored at one of the other fire halls and utilized for the other 4 fire departments maintained by the county, rather than contributing either after the fact or go forward to new capital equipment costs to increase the town's assets, which of course is just an operating expense for the county when it still has those same obligations for its own fire departments. With respect to the request for payment to mutual aid. I'll respond to that as well. Historically, mutual aid agreements, I think the evidence was consistent, including from the expert, Mr. West, that most municipalities went about the mutual aid agreements by sharing those services with each other without charge. Mr. West noted that he's seen some agreements now include a cost for service, and that even some agreements that had a cost for service included, there was in fact no cost charged between the municipalities. It was what it was said to be, a mutual aid arrangement. The town has proposed that the county pay for mutual aid where it's delivered by the town. I presume they also mean that if the county is the party delivering the mutual aid, that the county would charge the town for that service. And to that end, if that is something that as the arbitrator you are inclined to grant, again, I'm going to repeat the sauce for the goose and sauce for the gander approach, but so it should be equitable, and it should also be certain. And I think the reality is it should be taken note of to say, to the extent that the county has its own obligations for fire in those 4 fire departments, it should be enabled and not disabled by the ICF from acquiring equipment that it can use in for those purposes, and to reduce its cost for mutual aid to the town. So those are the other reasons for the capital expenses to be kept and the capital assets to be kept with the county, and that addresses any concern ideally that the town would have that there's use of equipment that the county isn't contributing to. The county can maintain its own and the town can maintain their own. With respect to just one last comment on the administrative overhead. On the administrative overhead, one of the concerns that I think has been raised is the issue of unforeseen or ballooning costs. And so that's one of the other reasons why on the certainty of cost item, we have asked for that not to be included, and for there to be, if there's some allocation made for reasonable items included within what the town is currently calculating as its administrative overhead, the same items ought to be included in any payments over from the county to the town to the county rather, and those amounts the county is asking should be fixed. The same principles should apply, and that would be the most equitable way to go about it. There really isn't a basis for the double standard otherwise. There's also, I think, something that, without intending to attribute any blame, I think there's a risk of complacency in the parties. If there is an administrative overhead charge or other charges of that nature, where one party is really asking for its costs to operate being funded in part by another municipality. In the past, I suspect this has been done to some extent all along, just less formulaically. So without the same structure as is now being implemented through the partial adoption of the Alberta Environment Full Cost Accounting Program for administrative overhead, I think there were clearly many of those expenses were already being included by the town, and there were questions about that. And I think that's one of the other reasons for the certainty in terms of the numbers. In terms of some other issues that I think we have with the certainty of the cost, water and wastewater is an area that if I can think back to your question about what is a service, a service under water and wastewater is, in the water case, the delivery of a commodity, and that is the foundation for that full cost accounting guideline that the town has relied on in Ms. Barney's witness statement. And it is to say you recover the cost that you incur to deliver the service. The town is asking for a 30% revenue sharing, what I'm going to call a surcharge, on all non-residential county land that could be connected to the water system that the county built and has to maintain at its own expense, insofar as that system is connected to the town's water system. The rationale for this and the evidence that it's based on is Mr. Smill's representations in his written communications that are included in both his general evidence statement and in Gordon Frank's general evidence statement from June of 2021. And there's the exchange of correspondence in which, and they're also included in Janine Scheck-Loberg's witness statement on water wastewater, where there's reference to this philosophical link or philosophical connection between the former revenue sharing agreement and the water wastewater agreement. And Ms. O'Kelly's already spoken to the $400,000 lump sum payment that was made by the county to the town, and it's specifically spelled out as being in lieu of offsite levies. And in addition, there's submissions made yesterday orally and as well in writing that there's some sort of equity in how the connection fee, the bylaw that's in place at the town, how it's applied to business properties within the town and business properties within the county. But that, if we look at the actual evidence, is not true. It is not evenly applied because in application, business properties within the town pay one connection fee to the town. The county, and this was in evidence through Ms. Scheck-Loberg, the county has no ability to charge a connection fee to business property owners in the town, but the town has, through the water wastewater agreement, imposed the ability to charge a connection fee in addition to the connection fee that the town who built and services and maintains the water system charges. A connection fee is not something, for example, that the Alberta Utilities Commission would normally take issue with if it were one connection fee. I would respectfully submit that the Alberta Utilities Commission might take issue, in fact, probably would take issue with two connection fees on the same property, one from a municipality that is not delivering the service. And the town, the evidence is unequivocal before you that the town delivers water to the boundary where the county connects. The county then carries forward that. The county's charged for the water that leaves that crossover point and goes into the county, and they pay the town that so many times a year. They're invoiced and they pay the bill. That has continued. It ought to continue. This is a simple commodity service that's delivered to residents, whether they're civil residents or whether they're business residents. It's a service that's delivered. It should continue on that basis without any additional surcharge. The only evidence in support of which we submit is this alleged philosophical connection. The evidence of Ms. Scheck-Loberg was that there was no agreement to this alleged philosophical connection or to the fact that those two agreements were linked, made by the county and the town in writing ever. There's no agreement on that. It is a fiction created by the town and that they are asking you to impose as part of the ICF. And they justify that by looking at section 708.36 sub 7 sub whatever it is. I have to go back to the section in the legislation, but the provision where I think it's F, where they're saying that you can have revenue sharing provided it's connected. You have the arbitrator you can make award under section 708.36 sub 7 sub F if the revenue transfer is directly related to services provided by a municipality that the revenue transferring municipality derives benefit from. And so they're arguing that you can impose that 30% on that basis. We would argue that there's no basis for doing so. It's explicitly a revenue share for the purposes of achieving this alleged philosophical connection, and the evidence simply does not support that. And moreover, the town, through its own unilateral decision-making powers, has already imposed a fee for connecting to that system through the water agreement that was in place, and through the IDP provisions that are in place, which again have not been reviewed, despite the fact the county isn't particularly would like a review, say that. And so what we have is the town's already got an opportunity. They're already charging more. And we have from Ms. Schecht-Loberg an admission that exactly no properties have been developed in the Woodlands Business Park since that double charge came into effect. 0 properties have been developed. So the impact on the county's business development may not all be attributable to that charge, but it's notable that in 8 years, from a number of development permits initially having been put forward, there's no properties developed. That cost is damaging to the business development in the county. And it is the leverage that the town has exercised over the county as part of its intermunicipal development plan and the former water wastewater agreement. That can't be replicated in the go forward agreement, and that is the effect that the town is seeking you to impose. And beyond that, if I understood the written submissions correctly, I think that I understood that amount, and if I misunderstood, then all the better. But I understood that amount was to be imposed where there was the possibility of a connection, whether or not the connection had actually been made. That the 30% charge was across the board for properties eligible to attach to the water system. And I would suggest that that offends even public policy, let alone doesn't have a home within the legislative scheme, including 708-36 sub 7 sub F. Further, I think that the request to impose the revenue sharing is contrary to the anti-fettering doctrine that we've discussed in our written submissions. And I think it shouldn't be permitted there. With respect to the certainty of scope, I think it is the parties, I think, are ad idem on the fact that each municipality has the jurisdiction and the legislative authority to determine service levels. Service levels for each service area are within the purview of council for that municipality. The ICF is an agreement to share some of those things when there is agreement, and even where the agreement's directed, it is still that, it's a sharing of those things. But the service levels ultimately, but for when they're fixed within an agreement and certain in that regard, are determined independently by the municipalities. And I think care should be taken in making an award in this arbitration that gives due latitude to each municipality to govern the services that are available to its residents and the costs that are attributed to that municipality if it's not the municipality delivering the service. And that there be a balancing of those elements, at least for the short-term foreseeable future, in light of the practical realities with respect to these two municipalities' disparate financial circumstances. The other thing I'd ask for with respect to the certainty of scope is that where capital expenditures are to be made in support of a particular service, So for example, if there was to be a capital expenditure proposed by the town with respect to, this is assuming for the moment that you are not ordering that the life cycle plans are adopted holus bolus as proposed by the town. Obviously, it's slightly different if you do that. But if the life cycle plans aren't imposed as a burden on the county as a contributing party, for example, for recreation, for all of the recreation services, then to the extent that there was a capital expenditure required, for example, on a facility that delivers a service, let's call it the pool, we would propose that the expenditures must be, the actual amounts of those expenditures be put through for vote by each council, so that again, they can be incorporated into budgets, and there is a fiscal accountability by the elected officials that are responsible for these agreements. Similarly, if there is to be any third-party servicing provided within a service area, you have our written submissions that unless the parties agree that third parties can deliver, are delivering a service, the service, if it's delivered by a third party and not by the municipality, doesn't meet the definition of an intermunicipally delivered service, and therefore ought not to be funded mandatorily under an ICF. If the parties agree to use a third service, or they're each parties to a contract, then we would say that would fit within, provided they're in agreement. And again, we've relied on the anti-fettering doctrine to make those submissions in our written submissions. With respect to some of the excluded items, I'll just touch on these really briefly. Excluded items that we've asked not to be included in the ICF are the contributions being sought with respect to the St. Joseph's School. The evidence was unequivocal from Janine Scheck-Loberg that there was no contract committing a promise to pay for the construction of infrastructure, repayment of debentures, or for any other manner in relation to the school. There was support for funding applications and so forth, but the evidence is clear that there was no agreement by the county to pay for those amounts, and we would submit there's nothing within the MGA that enables you within your jurisdiction to direct a payment for those past amounts, or an obligation on the county to repay the debentures alongside the town. With respect to the aerial truck, I believe that the evidence is, I understand that the evidence of the aerial truck is that it was brought into service after January 1 of 2020, but my understanding is that the purchase did not occur after January 1, 2020. And it's the decision to incur those costs was made by the town when it knew the county did not want to cost share. And notwithstanding that fact, the county is asking not only that you impose an obligation to pay for that capital cost item, but that you impose interest charges on that. The county rejects that suggestion, and we ask that you find otherwise. The municipal service, the municipal center, similarly, the capital infrastructure construction costs, Ms. O'Kelly's already addressed our submissions with respect to the law and how we think you should interpret it. But the county also notes that there is, the evidence is clear. There's no service currently being provided. There's no service to residents right now, and there's no basis for you including it in the ICF, either as a prospective service deliverer. I'm just going to note that with respect to general principles of contract, the municipal center doesn't exist. It doesn't operate, and it doesn't deliver any services. So I do not think that it properly belongs in an agreement between parties that's legally binding for the delivery of services. The other piece about the municipal center that I think was spoken to by Ms. Miller in particular is the affordability piece of that. I've already noted the representation with respect to the evidence that's relied on to say the county residents would use this, where I believe the document that we brought up on the screen earlier, page 37 of Ms. Grande's Municipal Center witness statement, as well. Ms. Grande's oral evidence in cross-examination, where she said that she personally had some conversations with people in Fort Assiniboine who thought they would attend the facility. And I would submit that neither of those are reliable and probative of actual benefit or likely usage by county residents. And moreover, lastly, with respect to the certainty of the contents and the scope there, the municipal center should also be out, leaving aside all those other reasons, because it is, even in Ms. Grande's evidence, a regional service. It's something that would be delivered to the region and ought to be viewed in that through that lens. And the town ought to do its homework about who else is going to contribute and not just ask the county to do so for the benefit of its residents, which at this point is speculative at best. But the benefits of other municipalities that would clearly, if everything the town says is true about the municipal center and the performing arts center within it, then it would draw from all kinds of regions and not just the county. And the county shouldn't be paying for that when it didn't agree to be a partner. The evidence is clear that it wanted to not be held out as a partner in the economics of this. The last theme is equitable. I'm just wondering if it's time for a break. It's 1:17. Do we need to?
And I'm just trying to think in terms of how long. So how much longer do you have? Will you be done by 2?
I think I can go through to 2 if nobody needs a break. So
No, but if we take a break, will you still be done by 2? That's what I'm trying to ask.
I believe so. We may have to be very brief about our reasons for omitting certain service areas and rely on the written submissions. But yes, I think we should be able to be finished by 2 or shortly thereafter, like very shortly after.
Okay, I have another commitment at 2:30 that I have to prepare for, so I'm a little concerned about time today. We'll take 5 minutes at this point.
Great. Thanks. That's way too much talking, man.
I know, I shouldn't have any questions.
Are we good to go? So I've used our 5 minutes to try to cut down on what I have to say here. I'll try to be succinct and we'll get us out of here at 2 o'clock. Ms. Howe, subject to questions. Are you going to reserve questions for tomorrow? Okay. So the fourth theme that we had proposed to discuss was the theme of equitability or equitable within the language of the statute. One of the things that I mentioned we would talk about there would be some double standards. We've touched on them already, just really briefly as examples more than anything, to say the principle is that it should be equitable. And as soon as we have 2 sets of standards for 2 municipalities that are in a collaboration framework, it raises the question of whether there actually is an equitable basis for that, unless the parties have principled reasons for agreeing. And it's clear that every witness that was asked that question, mostly by yourself, didn't have a reason. It's just the way it's always been. And so what we have is the most obvious examples are lump sum versus variable amounts and amounts that have increased substantially over time. That is not true with one limited exception with respect to the amounts payable by the county and paid by the county to the town over time. Those amounts over the 12 years of their past cost sharing agreement increased substantially. But for the contribution to the Recreation Society, I believe it was, all of the other amounts payable by the town to the county stayed exactly the same. The other areas in which there's a double standard is where there are equivalent, or what we call reciprocal. There's a reciprocity of servicing between town and county, but the costs only flow in one direction. And we think that factor has to be taken into account when you're considering, particularly with respect to services like FCSS, and more so with respect to recreation. There's ample evidence within the statements of Kara Kennedy and Heather Anderson on behalf of the county, and Ms. Grande for both FCSS and recreation on behalf of the town, to show there's an effort to show that by a town that somehow theirs is better and therefore the county should pay for it. We don't believe there's any reliable evidence that is actually probative of that fact, other than the ones that are conceded and the county is willing to pay for and has admitted that, which are facilities that are clearly distinct. I note that there is an indoor arena in Barrhead, and although arguably residents, as Mr. Snow conceded, for example, in Blue Ridge and Anselmo, residents in those two hamlets, both of which are within the county, maybe as likely or more likely to go to Mayerthorpe to use services there. The county's not disputing that the pool and the indoor twin arenas in the town are a service that is of benefit to their residents. To the extent that there are other services provided at the various facilities operated under the auspices of recreation or FCSS, the evidence is not sufficient. And so we would say there is some evidence before you, although it's recent in time, the surveys that were done by students for the county to demonstrate that that visitors to facilities that are operated and maintained by the county included numerous town residents. We realize that evidence is limited. And the reality is we were not asking for a cost share contribution. So the county had a different obligation to demonstrate benefit for which it was receiving funds. The funds attributed to the Hardlet Canyon, according to the town, are limited to $5,000. That's the value that they see for that facility. And that ought to be taken into account as well in your evaluation of what's equitable for the services that are provided, for which little to no evidence has been provided by the town of the actual benefit to county residents. I've already spoken about Ms. Miller's evidence with respect to the differential financial positions. And I think that the differential financial positions, while the county has its current circumstances and is working through those financially, And the town is not in the same boat. It's not, the county's suggestion isn't that it's somehow the town's fault or that it's its responsibility, but they each have responsibilities to autonomously run their own governments and make their own decisions about their own finances and where they allocate them and what resources they offer in times when things are flush and what resources and services they offer when they aren't as flush. And so each municipality, and that really goes to the questions, Ms. House, that you asked, Ms. Miller, and that she answered about how you navigate that. And I think that I will just leave it to you to rely on the evidence that was provided in response to those questions, because we think they are of assistance in assessing the obligations on an equitable basis. Excuse me. The one thing that I will sort of make sure that I know is the fact that you specifically asked some questions about increasing revenue on the tax side. And you noted that only the municipality that has authority over its tax base can raise its own revenues that way, or at least it can raise its taxes, perhaps no guarantee that it'll raise its revenue that way. And Ms. Miller noted that goes both ways. It applies to the town as well as to the county. So recognizing the county's current circumstances and depending on what you direct, the town has choices. And that was acknowledged by Mr. Snow when he was under cross-examination. He made a statement in his witness statement that the town would not be financially sustainable without contributions from the county. And when I pressed that point, he said we would have to refocus. And so I think the equities between the parties, even fiscally, is not the same. And the equitable solution to that is to make things that people really don't want to live without manageable for the foreseeable future while that recovery is ongoing. And not, to create a situation where one municipality at its own peril is subsidizing another municipality. And also on the equitable front, I will note that the evidence clearly shows that the town, as part of its administrative overhead, has provided memberships to the Miller Center and all the services that are available there, not just for individual employees, but for their families. That was Ms. Barney's evidence. And that Ms. Grande noted that what that looks like is not an actual payment, but it looks like a line item in the general ledger out from somewhere she couldn't identify to recreation, which is the creative accounting equivalent of moving money around on the books. But there's a cost to that service, and the cost is part of the administrative overhead that the town is being asked to pay for. And that is not an equitable principle that I think should be supported by an ICF.
You said town, county.
Oh, sorry. Ms. O'Kelly's pointed out that I spoke and said town when I meant county, or vice versa. So the county should not be subsidizing memberships to employees and volunteers with the town. It was really my point. And to the extent that those things are factored into the administrative overhead, and based on Ms. Barney's answers to the evidence that I asked her, they're included. Benefits of all kinds. There was benefits, remember, under the salary and benefits, and then there's other benefits. And Ms. Barney's only recollection that she provided in answer to my questions about that were things like the social club for town employees. When I asked her whether gym memberships were in there, I don't think she was certain about where exactly they fit within the benefits, but they were benefits that she included in as part of the overhead. And to the extent that there's no evidence showing that those amounts are backed out of what's being sought as an administrative overhead amount, I think you have to infer that they are part of that number. And I think that point has been a bee in my bonnet, I will confess. And it is because it flies in the face of what's equitable, which is prescribed in the legislation and within your jurisdiction. It is what you have authority to make decisions about, in part. Among all the various other things you have authority over here. And your authority, as Ms. O'Kelly pointed out at the beginning, is very broad. scarcely limited by few things other than the things that we're suggesting limited in the legislation. And so what we're asking for is for you to consider, as you're making your decision, the themes that we've identified, and we hope that they'll be of assistance to you in guiding your decision-making and your evaluation of the evidence to look at what ultimately is required, and that how the parties will, or if they may not, benefit from certainty in the various components of the ICF, how you can achieve a result and assist the parties in achieving a result and a path forward that is equitable. Not because somebody says so, but because as an outside observer and an independent decision maker, you have made that determination for us. On that note, I'm going to move on to the last piece I wanted to talk about. Oh, yeah. I already mentioned Mr. Richardson's evidence about equitable in response to your question, and I would just draw attention back to that, which is really just him sort of saying the parties figuring out what they're sharing, what it's worth, and how to split it up in terms of cost. And so there's an evaluation there, I guess, is what I'm really saying. And I'm saying that the equitable piece has to factor into your determination of what's in, what's out, and what it's worth. Our tab A document, I'll try to go through this quickly and keep us on track for time. Tab A, we have 3 headings. The first 2 tables are service areas that we acknowledge are service areas for sure, delivered intermunicipally, and they ought to be in the agreement. We've carved out water, wastewater, and the Regional Solid Waste Authority because we acknowledge that those have some other jurisdictional components to them. They have some oversight through other administrative authorities, including under the MGA. And that's the only reason really for specifying. We've specifically asked that the water wastewater agreement be something that is subject to review by the Alberta Utilities Commission, and that it not be something that automatically terminates on the end of the 5-year term. And really that comes about from the very facts that are in evidence before you about how that termination provision was leveraged here in a way that I would respectfully submit was not equitable or consistent with the principles of a collaboration framework. With respect to airport fire and the indoor pool and ice facilities at the town, we've spelled out, obviously, we admit there's a benefit. The airport, we're seeking a contribution. We have not put in specific numbers, and I don't know whether that's something that you're seeking, but there is an operating budget. We're looking for a fair contribution to the operating costs. It was not a request for capital contributions. If there's a finding that you made that capital contributions are warranted in any respect from county to town, we would ask that the same principles for the sake of certainty and otherwise and equitability apply with respect to the airport. With respect to fire, we're asking, as we noted, for a fixed cost contribution. All of the items that are in should be subject to the dispute resolution provisions in the ICF. None of them we submit should include administrative overhead for the reasons we've noted. With respect to airport fire, with respect to fire, the recreation items noted, the waste authority and water wastewater, those are contribution items for the county to make to the town. And the airport is an item for the town to make to the county. We would be asking for the contribution with respect to Grove Creek Group Campground as well as Hard Luck Canyon to be in the agreement, and the amounts should be something that is determined based on what the actual costs are. Go forward, that is not, we concede that that item is not specifically in evidence, but an equitable sharing of the costs of those items should be included proportionately. And if the amounts are the same for the period of the immediate agreement, then because that's all the evidence you have, then that is how it shakes out. With respect to the Regional Solid Waste Authority, we are, as I noted earlier, asking for an alteration of the terms of that agreement to be based on actual, much like the fire request that is being made by the town, we'd like the volumes of waste being the measure, not proportionality based on population. It's also simpler. It's something that's tracked already at the facility, and then it doesn't require any sort of apportionment for volumes of population and allocating that. Again, we had put in no administrative overhead, but as I understood Mr. Ward's submissions yesterday, that's not an item that's in there anyways. We did ask that if there, the county asks that if there are substantial capital cost items to be included in that facility that the town is seeking contribution toward. Again, any massive changes financially in the numbers, including the admin that's already charged there, should be put to a quorum of each council for approval. And I would suggest that there'd be like a threshold number for that so that it's not small ticket items. Just as a matter of efficiency and accountability. With respect to things that we say should not be in, the balance of the recreation services, unless there's a finding of a benefit that's established in the evidence, we don't think that's appropriate. FCSS, the county notes that it does provide its own services that's clear on the evidence. It also provides funding by way of grants for community, arts, culture and recreation, and services for seniors and families through its own funding. In addition, it does receive grant funding. The grant funding is from the government. There's no certainty with respect to that going forward. And ultimately at this stage, the evidence doesn't support which, if any, county residents, the numbers that are tracked by the county for FCSS services are remarkably small, as I noted. So we don't think the evidence is establishes a benefit that warrants a mandatory contribution to the town. Roads and railway crossings, we've noted that these are both reciprocal issues. The road agreement that the town relies on was repudiated. It was a contract, and it was repudiated when the town annexed the land that made that agreement reciprocal. There's no longer a reciprocal agreement for providing services, and the road maintenance isn't an intermunicipal service. It was continued in part pursuant to contracts, as Mr. Bashan noted, and evidence on cross-examination. There were existing contracts for service, and the county had committed to paying for that service to be done on the town roads, so fulfilled that, notwithstanding the notice to not continue doing service. We don't see a basis for that intermunicipal infrastructure service, infrastructure item to be included in the ICF go forward. Railway crossings, similarly, really don't see any evidence showing a benefit to county residents of the railway crossings. The representation is that there's rail traffic because of the gravel facility, and that somehow that provides a greater benefit to the county. This isn't an intermunicipally delivered service, the railway crossing, and the control over where those railway crossings were placed was entirely within the town's jurisdiction, and that is in evidence from the cross-examination of Mr. Smill. Further, if it's an infrastructure item and not properly part of an ICF. And the municipal center, I think I have probably, between Ms. Kelly and I think we've said it a fair bit. It's also in our written submissions. But I think importantly, there's a number of fronts on which that one is not consistent with the principles in the legislation, both in terms of it being a future capital contribution, in terms of it not operating currently, in terms of it being a request in effect for you to restrict the discretion of future council to either choose to participate in any ongoing development or service that's provided to that, should a service actually be provided through that facility. And so we would say it offends also the anti-fettering doctrine. And there isn't evidence to demonstrate a benefit that comes from a service that's delivered intermunicipally on its face. So ultimately, it's not subject to the ICF provisions at this stage at minimum. The school, again, excluded because of capital and infrastructure. We're saying also the town is asking for repayment of debentures. I see that as being akin to the revenue transfer piece and not within the scope of your jurisdiction to award under the terms of the ICF provisions in part 17.2. Transit, The benefit is not established on the evidence. Intermunicipal service is not established on the evidence. And it is a user fee service. I would say it's not a user pay in the sense that it's not fully funded by the users. Generally speaking, I think it's fair to acknowledge that transit systems tend to be, I think the term is lost leaders within municipalities, and we acknowledge that that is the town's choice to offer that service. It's not a service that was ever agreed to or ever previously in an ICF, and so you also don't have that contextual variable. On the front of cemetery, I don't believe it was in evidence before Mr. Ward tendered it yesterday, but Mr. Ward pointed out that there is a cemetery that is within the county that's been acquired by the county, and had that been in evidence, we would have argued the fact that there was a reciprocity piece. But I think even beyond that, cemeteries are a funny thing. I think unless these parties agree to it being included in their ICF, I don't know how you find that the residents have a particular benefit in that you can't, I mean, we don't have very reliable data that is of any duration, and it's acknowledged that the evidence isn't really there to show there's a benefit. The duration of the evidence that is available is incredibly short. And I don't think it goes to establish that there's an intermunicipal service being provided there and that there's a publicly funded cemetery. Alternatively, we would say that the cost being sought is in an amount that ought to be recoverable through using higher rate pays, and if the town wishes to continue to offer that service, it may do so by raising its rates, and including by not giving a discount to county residents. Forest Interpretive Center, interesting submissions from the town and that we own half of it. The evidence from Ms. Wharton, I reject the submissions by Mr. Ward to say that, to say only that Ms. Wharton's evidence was that county administration doesn't use the center. That absolutely is true. However, the other evidence on the Forest Interpretive Center from Ms. Grande is that if residents of the county use that facility, they must pay for it. And there's no suggestion that residents of the county get any kind of preferential treatment there. When the Visitor Information Center, there is a reciprocity piece to the Forest Interpretive Center in that it has a museum through the Heritage Park and it has a Visitor Information Center, but so does the county in Fort Assiniboine. And in fact, the contribution for the Forest Interpretive Center, just factually speaking, is about $100,000 a year, just over, in recent years by the county to the town, for which I cannot see, but for some pamphlets at the Visitor Information Center, which are also the case at the Fort Assiniboine Visitor Information Center. But for that, there doesn't appear, and the Groat Creek campground bookings, there doesn't appear to be any benefit whatsoever to residents of the county. Certainly not a benefit warranting an expenditure of $100,000 plus per year. Housing a lift station that's maintained and paid for by the county, I don't think warrants that expense either. And if you're going to rent out that space for the lift station, I'm pretty sure it costs less than $100,000 a year. The library, we say there's a reciprocity piece to that, even if there was an obligation to contribute to third-party delivered services that are independent statutorily. There is in play an agreement that's been proposed and some modifications, I believe, made by the library board back to Woodlands County. The last evidence you heard was that that had not been concluded. Our submission is that you don't have jurisdiction to bind the parties, town and county, to another agreement in addition to that, when the county has chosen to fund the library separately. And I think this goes really to the administrative overhead piece. And I think it's a precursor to the municipal center argument that you or somebody else might hear if the parties can't agree on that some years from now. And I would suggest that it not be included on the basis of everything that's before you in the ICF. Police Protective Services. the evidence is confusing on this in the sense that as best as we can tell, it appears that these are services still delivered by police officers. And so therefore funded through the provincial policing costs. If what the town is asking for is a contribution to their portion of the policing costs because the position was established when the parties had a different agreement, there still needs to be a benefit demonstrated to county residents, which we don't see in evidence. And then on top of that, I think if the county no longer wishes to fund those, or sorry, if the town no longer wishes to fund those services without a contribution from the county, it has that option. It isn't required. It chooses what it contracts with the province to provide by way of policing, to my understanding. 8 minutes left. That's it for me. Subject to your questions, which I appreciate you will want to park, given the time. Thank you very much for all your the indulgence and the very short break that allowed me to get done in time.
Thank you very much. Okay, so we're going to start at 9 o'clock tomorrow morning. Ward, I think you were going to do some sort of rebuttal if you have anything you want to say. I think both parties have tried to include their response already in anticipation, so I'm not sure how long that period will be. And I'll go over the questions that I had prepared after reviewing your written submissions and get them organized for tomorrow. If I can send any of them to you by email in advance, I'll try and do that just to give you a little bit of heads up time instead of trying to think on your feet. So, okay, so we'll be here at 9 o'clock tomorrow. Thank you all very much and have a good evening.
Thank you.
Thank you.
Go.